Welcome to Looking at Legal Stuff. Today we have 8 hearings, including a missing hearing, in the case of a couple where dad was incarcerated up until several years ago, but he's done everything asked of him to return to the community and be in his son's life. But mom and her lawyer have spent the last few years throwing up every roadblock possible, and now their son is getting frustrated and angry, and he's starting to act out. Can these parents ever be civil with each other? Let's find out.
Anybody else want to call a case, or I can just start going down the list?
I'm happy to call. If the court would take Rance and Vic, this is cause number 23-000-8208.
Yes. Good afternoon.
Good afternoon, Your Honor.
All right. So this is a motion to modify the temporary order and parenting plan.
Correct.
And I know that I have something. Ms. Jeffers, did you submit any orders?
I did not submit any
Okay.
orders, Your Honor.
I just don't want to dig through the pile for something that may not be there. I know Ms. Baldwin submitted a parenting plan, so, okay. All right, go ahead, counsel.
All right, very good. For the record, I'm Chelsea Baldwin. I represent Jonathan Rance. This is our motion to essentially modify the current temporary order and move to a regular parenting plan. I do think the procedural history in this case is important. My client at this point has been doing reunification counseling for more than a year. But when you look at that procedural history, it does inform sort of what has happened and what is continuing to happen. My client was released in the very late summer, sort of early fall of 2021, sort of got his ducks in a row, made sure he was ready to start reunification. And filed for reunification in November of 2021. And from there, Mrs. began sort of delaying the case. We see the court finally ordering reunification December 13th of 2021. The court set an outside review of February of 2022 to make sure that that had started. When we get to court in February, no progress had been made, not even an appointment scheduled at that point. The court essentially said, all right, we'll come back in March, make sure that you've actually begun. At that point, we come back in March of 2022. She still had not even set an appointment to begin reunification counseling. At that point, the court essentially orders that she schedule an appointment within the next week. Essentially, your feet are now absolutely to the fire. From there, reunification counseling finally starts to begin, but you see that she continues to frustrate and delay the process. In June, she's held in contempt for withholding information about the child. June, again, there's a separate order that requires her to provide specific information about the child that she's withholding. In July, we're compelling. There's an order to compel because, again, she's withholding information. August, she faces sanctions for continuing to, faces and as receives sanctions from the court for continuing to withhold information. So again, there is just a very long history of obstruction, withholding, and attempting to alienate the father from the child. In this case, the court-appointed reunification counselor was Charlotte Rosen. We have provided her letter for you as part of the materials. She is the court-ordered professional. Her letter details essentially 10 months worth. She's continuing to work with the family of her work with them. She talks about the fact that essentially about 5 months in, around sort of mid to late summer, this is kind of a tween, preteen child. He's kind of done with this reunification thing and is ready to move on. From there, there's no issues reported by anyone. So Charlotte Rosen talks about, I checked in with mom, I checked in with dad, I checked in with other people. Nobody reports any issues. They move forward to hybrid visits where the visit starts in her office, then father and child go off somewhere. That visit sort of ends in her office. Again, no issues, no problems. Those go great. She checks in with mother. There's no issues. Mother agrees. They move forward to having 8-hour visits. So now we're having longer visits. Again, she details in her report, I check in with mother, I check in with father, I check in with third parties that are on the mother's side. These are sort of mother's interested people. No one reports any issues, any concerns. So at that point, Ms. Rosen moves forward saying, okay, it's time to begin overnights. We have this great overnight opportunity for the child where he was going to go snowboarding. Grandparents on my client side were along, so sort of all the safety factors are completely in place. No one has any issues. Everything's all approved, child told. And then mom says, oh, I found out I don't have to do this. So no, go back to 2-hour supervised in-office appointments. Even though that's not what we've been doing for months, even though there are no reported problems or concerns, it's just, no, I don't have to do this. So I'm going to do something that's detrimental to the child. There was nothing that had changed. There was no event that had sparked that request. It was just, I don't have to, so I'm not going to. And even though, again, we're months down the road, this was just her desire. So at that same time, my client expresses interest in going to the child's events, his sporting events, his school events. Mom says, no, you can't show up to those. If you even show up to, a basketball game or football game, well, gee, that's a violation of the order. So you can't even do those basic things. So again, that alienation, that control, and we have that continuing pattern of withholding. Where we are today is we're now still stuck in 2-hour fully supervised visits that the reunification counselor says are not appropriate. They haven't been appropriate for months and months and months now. And I'll relate to the court, some deep concerns about the timing of sort of when those visits were ripped back. But I think it's important that we talk about the respondent mother's sort of statements of concern and where she says, oh, these are the reasons why, we shouldn't move forward. We shouldn't progress. We shouldn't have even gotten to where the trained professional said we should be. And the reality is all the concerns she relates and reports are essentially 5+ years old. They are extremely old. And there is no new issue that she's reporting that has a current concern. First, she says there's no connection, that there's no bond. Again, Ms. Rosen's report directly contradicts that, says dad and child doing great, had a pretty quick reunification. They were doing really well, continue to do well, that they're relating well together. It's notable that my client recounts that while he was incarcerated, he tried to call the child, would send the child letters, but mom was, again, so focused on breaking that bond and withholding that she said if he continued to do that, she would seek a restraining order against him and try to get this court specifically to get a restraining order against him if he even sent a letter to the child. Even if she could open it first, even if it was fully appropriate, if you even send a letter, I'm going to get a restraining order, which was really critical. My client was involved in a very low supervision facility. He was part of a firefighting program, part of a facility where essentially the restriction is so low that he could have walked out the front door. Like there really wasn't, there's a gate, but it's not locked, was the type of facility he was at. And again, being allowed to go out on the wildline fire lines, and all of that would have been ripped away by that restraining order because it would have meant a change in his status. So again, my client couldn't even send to child letters based on mother, but my client continued to write letters. He just sent them to my office, and we provided the court with a smattering. We didn't give you all of them because that would be too much. But again, they're all appropriate. They're all reasonable. They're all child focused. Mother's focused on breaking that bond. But again, that bond exists now. They've been in reunification counseling at this point for a year. It's ridiculous to say they aren't fully bonded. The next issue she raises, he's a rampant drug user. But again, let's go back and look at the evidence. The evidence is that from day one, she's had the power to drug test my client. The only time she requested a drug test was at the initial hearing. And when it came back clean, she refused to pay, even though it's a loser pays type situation. So again, the single time she's asked for that, she has not asked for a single hair follicle since that time. So again, she's not concerned. She said, he was driving high. She should have had him tested. But again, he wasn't. And my client provides for you a clean hair follicle currently that shows that he wasn't. So even if you were to believe, sort of her fears, those hair follicles go back 3 months. So again, not an issue. Was never driving high with the child. That simply did not happen. And there's no evidence to support that. And even she didn't think that happened because she didn't ask for the hair follicle. I'll note that it's important for the court to remember that my client in October or November of last year had major surgery. That surgery required prescription pain medication. My client got off of that as soon as he rationally could, because again, he didn't want to be on that because of his history. And now we have, again, that proof of sustained sobriety because we have that proof of now he's 3 months clean. And again, he had a surgery where it was required, it had anesthesia, significant issues, but again, he's clean. So that does show his commitment to sobriety. Next, she claims, oh, well, he's at the vape shops. That proves he's doing things. No, you can smoke tobacco, you can vape, you can use things that are legal. He doesn't even have THC in his system. So again, that current hair follicle and the prior hair follicle show he's not using anything at all. She next says, well, make him, even though I've not asked for a hair follicle, essentially this entire case, except for the first get-go, make him have to do them quarterly. And so if he has to do them quarterly, that's about $600 per year. So she doesn't want to pay it. And she just instead wants the court to make him have to pay it. My client's fine with maintaining the loser pays language. But again, now what she's doing is she's putting the onus on my client to provide the $600 essential product or he loses his visitation. Again, she hasn't had that concern. It's not reasonable that the court implement something like that. Perfectly happy to have the loser pays drug testing language to be maintained. Next is he has a violent past. My client cannot change what has already happened. From day one, after that crime was committed, he owned it. He pled guilty for it. He did his time. He used his time while he was incarcerated to take advantage of essentially every program they had. He did parenting classes, took sobriety classes. He did the wildland firefighting program. He supervised others in that program. So again, we're in a situation where he did everything he was supposed to do and used that time productively to turn his life around. And he's essentially been very honest with the court that sort of that period of time saved his life and put him back on the right path. So he's owned that from day one. But since that day, at this point, many years ago, there's nothing that's happened since. There is no indication, no concern, no text message, no email, no letter. There is no nothing that would indicate any concerns that he has continued anything along the lines of violence. So again, learned his lesson and has done everything possible to show the court as such. We are asking the court to adopt our parenting plan. This is a young, sort of again, tween, preteen. He's ready to move on with his dad. This is life. He's ready to get on with it. My client is more than willing and ready to get on with it. And this is what Ms. Rosen has recommended for a long and extended time at this point. Our plan is where we should be. It's essentially moving forward to regular visitation, which is appropriate. If the court wants to do some sort of ramp up, that should be extremely fast, like over the period of a single month. Like we're going to do overnight visits for 2 weeks, and then we're going to move on into regular weekend visits. I'll note that we are asking for fees in this matter. This is an instance where this is bad faith. Again, and that's where that history comes into effect and where we have to think about the fact of how the respondent mother has drug her feet for extended periods of time. And at this point, I would argue has caused financial harm to my client, but also to practical harm to the child, in forcing him to be in reunification counseling, essentially in a small room where you're stuck there for 2 hours and you can't do anything. That's ridiculous, especially when my client had moved to a point where they were doing entire days with no one reporting any type of an issue. The timing of this is important. Again, I relayed to the court, my client had an injury that was an on-the-job injury that he had. He had major surgery that put him on L&I. That means his income was substantially reduced. That's very close. Shortly thereafter is the time where mom says, yeah, we're going to yank back those visits. It happens within the next month or two. So again, real concerns is, oh, well, you can't pay to get back into court. So now we're going to use that to withhold and try to move everything back. We have no one voicing any concerns, no one reporting any problems, everybody reporting that things are going well and appropriate. And mom just says, no, I'm going to take you back to 2 hours, fully supervised, sitting in a tiny office, because that's what I want. That's bad faith. That's not in the child's best interest. And I think everyone here can relate that it's not in the child's best interest. We're asking the court for $3,500 in fees and costs. That $3,500 is considering not only my fees for this motion, but also the fact that these parties and my client specifically has paid substantially for reunification counseling. It really isn't needed anymore. We're way past that, and we were past that months and months ago. We were progressing to a point that was reasonable where we were ready to move off anything to do with Ms. Rosen until mom sort of pulled this latest thing out. So we're asking for $3,500. I think that is reasonable in this instance. So again, we're asking the court to adopt our plan, allow this child to move forward, allow my client to move forward. That is in the best interest of the child.
Thank you. Ms. Jeffers?
Your Honor, I'm just going to start with a clarification of a couple of issues. Father likes to take advantage of the fact that mother was unrepresented for a long time. Her income is $700 a month. Since I took over representation, there hasn't been any issues. And as far as who's alienated the child from the father, father's own actions did that. It's not mother can't take responsibility for the crimes he committed or the incarceration. He is extremely assaultive, and quite frankly, father says, oh, there's no text messages or phone calls since I was convicted, but that's not true. The reason that communication was terminated was because of the abusive nature of the phone calls by father. Mother's requesting that you adopt her parenting plan, which is certainly not in bad faith. It is consistent with the recommendation of the GAL. Father likes to only take consideration of himself when it comes to this case. Mother's trying to take consideration of the child. She's also asking for an award of attorney fees. The problem is that since we filed our parenting plan, that father's provided evidence that he's taking generic Adderall, that to her understanding is not recommended for prior meth addicts, meth being the drug that he was on when he committed the crimes against him. If you look at the hair follicle test, you can see that he's testing positive for amphetamines. And quite frankly, Adderall can be abused and lead to continued addiction. It seems to also be that he is taking that on a regular basis, which alone can be a basis for a DUI. And he's been driving the child around apparently on it. Father does have significant 191 factors. This is undisputed that he has felony assault convictions. He doesn't put that in his parenting plan. Obviously, that's true, but he says, no, it's not. He obviously has long-term problem with substance abuse and now is taking a legalized form of amphetamines, quite frankly. He says, look, mother is a drug addict. But the reality of the situation is that all of her tests are clean. She has never had an issue. She doesn't have any arrest history. None of that. Mother is also, and with regard to requesting hair follicle tests are very expensive, especially when you are pretty much solely supporting a child on $700 a month. Mother also alleges that he abandoned the child, he's neglected his duties, that he is engaged in significant domestic violence when it comes to her, including the threatening calls that he used to make from jail, that he uses an abusive use of conflict. What's strange here, Your Honor, again, is the concentration should be on the child, where the child's comfort level is. And all father has done throughout this entire case, if you read through his declarations, are attack mother again and again and again. They have a phenomenal son, and she is the person that has raised him. Father has no credibility before this court. He outright lied in his declaration and said he's been clean for 8 years, but he was only arrested 5.5 years ago while he was under the influence, and we submitted that information. Again, he says mother used to have a substance abuse issue, but there's absolutely no evidence of that. He lied to the reunification counselor when he represented that the court said she was determined to determine visitation. That was not true. That was just a bullying technique against mother to try to make her feel like she must agree to everything that he was asking, quite frankly. And even as he just spoke, he said, oh, they're having 8-hour visits. I'm looking at the information from the counselor saying they had 4-hour visits. He is not honest with this court at all. And that is concerning to mother. In the past, he's never been able to maintain sobriety, and he's not sober now. He's on prescription amphetamines instead of regular methamphetamines. There have been multiple purchases at his old head shop. This is something he doesn't even deny. And he admits that he was on major narcotics for surgery, which is an issue for someone in recovery. And these are all issues that anyone with a young child would be concerned about. And that is mother's main concern, is the physical and emotional safety of this child. He's a great kid. He's a sensitive kid. He, is a people pleaser. And father has taken advantage of that, quite frankly. Mother denies hindering father's visitation. Again, what she's asking for now is supported by the recommendation of the GAL. And, she just asked that father be sober. I'm not sure how to address this issue in that he isn't. He submitted a hair follicle test showing that he is not sober at this point. Again, both parties have been subject to motions to compel. The counselor says reunification counseling has been regular. Again, the issue with the reunification counselor is that she has okayed father driving with no checks to make sure he was sober, and now we know that he was not. He lied to her about her role and used her to basically strong arm mother into things that made her uncomfortable. And father has a history of this behavior. The child has suffered as a result of this behavior. Father has been putting a lot of pressure on the child since he's had unsupervised visitation. The child fears standing up for himself with dad.
So I'm going to object. That's not anywhere in the record. So it's not in Ms. Rosen's report that there's any sort of fear expressed by the child. The child's been pressured. That's just not anywhere in the record.
It's in mother's declaration, just
That
as
would
you.
be hearsay with no evidence otherwise and no foundation.
All right, that's noted. Go ahead, Ms. Jeffers.
Your Honor, father has never been the primary parent of this child. The child didn't even know who he was until 17 months ago. And the child has only known father for the last 10 months. Yet father wants the court to pretend he's been like a normal father all along. And that's just not true. Father has attempted to interfere in relationships where the child has had a good male role model. And quite frankly, father disparages mother to the child, comparing homes, even though he lives with his mother. In the 18 months since his release, he's been unable to obtain his own housing or hold down a job. And that certainly isn't a sign of progress on his part. He's still living off others and unemployable. Even father's own stepfather into the GAL seemed to express discomfort with father's interactions with his younger brothers who are closer to the child's age. Mother is proposing a step-up visitation consistent with the GAL recommendation once father is sober that puts the child's interest above that of either of the parents. She really wants father to maintain sobriety, to include prescription medication. And mother also requests $1,500 in attorney fees. There is a gross disparity of income between the parties. Based on the child support worksheets, his is about $2,000, I believe. Hers was $700. Father paid no child support for over 5 years, leaving mother with the full financial burden of raising this child. It is father's own actions why we are here, not mother's. Mother had to pay 50% of the reunification costs, even though father is the one that got himself thrown in prison, and even given the disparity of incomes. Mother paid significant fees when father took advantage of the fact that she was unrepresented and pro se. Mother requests that you adopt her parenting plan and award $1,500 in attorney fees. Thank you, Your Honor.
Thank you, Ms. Jeffers. Short response.
Yes. Well, first, counsel's wrong when she says that they were only on 4-hour visits. If you look at page 2 of Rosen's report, third paragraph, it's clear that they were already on 8-hour visits. So again, that's just an absolute misstatement of what Rosen's report says. Number 2, there's no history of assaultive behavior since my client's criminal conviction. There's no proof of these calls ever being threatening. Again, the letters that we've provided show that my client was more than appropriate. This idea that you can have a DUI with Adderall, no, not at 10 milligrams. And again, it's ridiculous that counsel's now trying to be a physician and act as if a physician cannot prescribe appropriate medication. There's a low dose for Adderall for an adult. So again, not appropriate. 191 factors. Again, my client does not have any DV assaultive history. It was a stranger. That was, again, many years ago. So that's not appropriate. This idea, during my client's surgery, I'll clarify, he did not use narcotics other than the anesthesia. He used nerve blocks to avoid having any narcotics, any opiates at any time. So just so we're 100% clear, my client wanted to not impact his sobriety whatsoever. He's been completely clean and sober. The Adderall does not impact that. My client was the primary parent per an Oregon court order. So again, we do have a history of my client being the primary parent. My client also maintained a job for approximately a year before he was injured on the job to such an extent that he had to have major surgery. So again, this idea that he's unstable, simply not true. And again, where we know that they are exhibiting bad faith is that their own current proposed parenting plan is offering an 8-hour visit, and yet they've ratcheted back to a 2-hour visit, and until we're here today, really aren't offering anything more. So this idea that they've ripped my client back to 2 hours, but now say, oh, well, we'll give him 8, that doesn't make any sense. Then why have we placed my client at 2 hours when even you admit it should be a minimum of 8? So I was in the court, it's time to move on. Again, their acts do exhibit bad faith. Fees and costs are appropriate. My client's on L&I. She's fully supported by a third party. Fees and costs are appropriate.
All right. I just went back and looked quickly at the Ms. Corey's GAL report and recommendations, and I'm reviewed a large chunk of this case. I understand the frustrations of the parties, and I understand both arguments. I know that mom's position as dad willfully removed himself from their life based on his actions and then incarceration. I also understand that dad's trying to do everything he can to make up for that time and be present in the child's life moving forward. I reviewed Ms. Rosen's report a couple different times, and looking at that coupled with Ms. Corey's report, which isn't about 4 months old at this point. I think it was filed in December. So relatively new information. And frankly, I don't know if everything from that report was addressed by the court after the report was filed, because it also indicates that mom should have a drug and alcohol evaluation and whatnot. So I don't know if that's happened yet. I'm not looking to go there, but clearly there's a lot going on here. Miss Rosen is a professional. I think we're all very aware of how many cases she's been involved in, and Miss Corey's report essentially defers to the reunification counselor and what kind of structure should be provided moving forward, and offers a step-up plan. The proposed plan, sorry, I'm waiting for Odyssey to load. The proposed plan by mom is essentially contingent on dad being sober, a hair follicle every 3 months, alternating Saturdays after 6 visits, alternating weekends after 6 successful weekends. And that's weekend, Saturday to Sunday, after 6 successful visits, alternating full weekends, so Friday to Sunday. And I don't think either party's proposal is too out of line. Here's what Ms. Rosen indicated, that she wants to see the child hooked up with a regular counselor. Is that something that has been done at this point, or is he still just seeing Ms. Rosen?
Just Ms. Rosen, Your Honor.
Okay. Here's what I'm going to do. I'm working off Miss Baldwin's parenting plan. I understand that the previous temporary parenting plan had a whole a list of 191s that were involved. This parenting plan doesn't list any. I don't think that we can just omit those other findings. And some of them were reserved for trial. So I'm going to keep the 191 findings in place that were made initially. I am going to work towards, so we're going to change things to joint at this point. And what I'd like to do is, we've been away from 8-hour, or I guess full day visits between dad and child for a handful of months now. Is that fair? So what I'd like to see is, let's do 2 full day Saturdays.
Yeah. Is that per the counselor's recommendation, 10 a.m. to 7 p.m.?
If everybody agrees with that, and that's fine with me. I don't care about timing.
I'd ask would be 9 to 7 if that's all right. I mean, if my client, he doesn't live locally, he lives south, that just gives sort of a more regular day. If it's a Saturday, that doesn't impact school.
Well, and I mean, I generally would not disagree, but he is a tween who likes to sleep in on his weekends too. So 10 a.m. seems appropriate. It's a longer visit than father's ever had with them.
Yeah, the recommendation is 10 to 7, even in Miss Baldwin's parenting plan. So we'll keep 10 to 7. So I want 3 full days. So 3 full Saturdays of visitation.
Are those going to be sequential? So essentially every Saturday for 3 Saturdays?
Barring any pre-made plans mom may already have had. Yes, that would be ideal. And then I'd like to switch then to every 1st, 3rd, and 5th weekend, Saturday, 10 a.m., Sunday, 7 p.m. And I would like to do that for I want to do that for 6 weeks. And if there's no issues, then it'll be the same weekends, 1st, 3rd, and 5th, Friday at 5 to Sunday at 7. Ideally, if there can be a check-in with Miss Rosen at some point during this process, just so that child, I would assume, is comfortable with Miss Rosen at this point and would hopefully express any concerns that they may have with her. Or if there's a pursuit of another counselor that, that process be started. But I'd like Miss Rosen to at least check in on this case for another month or 2. So we have somebody that has some history. So if just the child meets with her maybe once or twice over the next 3 months.
And Your Honor, if there are issues, so that should the child report that to her? I'm not sure what to do if there's a problem.
If there's a problem, hopefully, yes, there would be an appointment made and he could get in and talk to Miss Rosen. And then obviously if there's a concern, I can always bring it back before the court. Needless to say, Ms. Baldwin, I think I marked up your proposed order a little too much to use it. So
I do want to address though, is the court ordering any summertime, any additional time to be used this year?
And Your Honor, my concern with that obviously is we haven't even got through an overnight visit. So maybe it would be more appropriate that we come back.
I'm not at this point, no. However, after we get through a few actual weekends, Friday to Sunday, if we still have some summer left, which we should, I'd be happy to reconsider at that time if things are going well.
Okay. And then similarly with holidays. So mother's proposed parenting plan had 0 holidays for father. I don't think that's appropriate. Holidays are important. Some of the holidays, for example, Father's Day are important. Though my client should have Father's Day this year. My client should have the 4th of July. Those are opportunities to build memories and do those important bonding things.
I will, so Memorial Day weekend, I'm just thinking of the upcoming, I'm not making, if that's dad's weekend, great. If it's not, doesn't, not including Mondays for holidays to dad's weekend at this point. Mom should get Mother's Day. And so even if that's just a return home, if that's dad's weekend, maybe he returns home, the child home by 10 a.m. that day instead of 7. Dad should get Father's Day. Ms. Jeffers, does your client have any strong position about 4th of July and evening visitation for dad on that day?
I haven't talked to her about that, Your Honor. I mean, her concern is sobriety, obviously.
Well, here's the deal. I'm willing to give 4th of July to dad, as assuming that nobody has any dire concerns about that. I understand the sobriety. Dad should maintain the sobriety. I'm not real concerned about the prescription Adderall that he's taking, especially in the dose that he's taking, as long as that's under the orders of a medical doctor. If there are any concerns with sobriety, that can be raised at a later time. Labor Day, if it's dad's weekend, great, just doesn't include the Monday.
And I'm okay to come back and address 3-day weekends sort of towards the July, beginning of August, kind of as you indicated. July 4th is kind of like the first one that's fairly close that we should address, but the rest of them I'm more inclined to let those lie for now, and with the court specifically allowing us to address those later in the summer.
I agree, Your Honor. And just to clarify, what are you looking for July 4th? I mean, is that a day visit?
I would ask that it be wherever he's at. So if he's at the, you sort of said like, these 8-hour visits or 9-hour visits from here, and then these are overnights from here, whatever he's at, we'll just make that the same July 4th visit. Is he has the same amount of time? I
disagree. That wouldn't give him 2 overnights for a 4th of July visit.
It would be he could have, for example, July 4th at 9 a.m. to July 5th at noon or something like that. July 4th is a generally evening holiday. So to say return kid at 6, it's like, well, you didn't really get the 4th of July then.
And Your Honor, father's going to continue to provide transportation. Is that correct?
And that we need to address.
Okay, as far as 4th of July is concerned, let's do, it is an evening holiday, it is a date. Let's do noon on 4th of July to dad until 10 a.m. on the 5th. And math wise, we should be at overnights by then. If something stymies that, then obviously that is based on him being at overnights at that point. If he's not at overnights at that point, then that wouldn't apply. Okay, so then transportation, let's address that.
So my client has provided 100% of the transportation for more than a year now. That's not appropriate. It's appropriate that both parties at this point engage in transportation. So we're asking the court to just move to the standard pick up to begin your time. That's appropriate. If mom wants to choose a location up here, that's fine. Certainly have no objection to that. My client can do the same near his location if she doesn't want to pick up at his house. But if my client's providing 100% of the transportation, then there needs to be a substantial transportation credit given to him in child support. It's a one or the other. The statute's pretty clear. So we're asking at this point just to move to both parties picking up. They are both arguably low income. My client's counsel says he's unemployable. His most recent history is L&I due to a substantial injury. So they're both sort of in the same position.
And Your Honor, I disagree. The child has lived in this area for a significant amount of time. Father has made no effort to move towards this area. He's living in Lake Oswego, and mother doesn't provide transportation. She relies on third parties to do that. So that's a pretty big ask. We would ask that for the time being, father continue to provide transportation. If the court thinks that mother should provide some, then I would ask that she get to choose whether it's drop off or pick up.
That counsel's statement is not the legal standard. His child's lived here for a long time is not the basis of child support in that decision.
Child support
aspect is the financial aspect is laid out in the statute, and that is if one parent provides all the transportation, you have to provide a credit for that in the child support worksheet. Child support is currently $304 per month. So again, the idea that she would choose which she does is kind of messy. I don't like it just for that reason, is there's a lack of clarity there on who's obligated. If the court wants to obligate my client, that's fine. But then he should have a credit.
And Your Honor, motion for modified child support is not before the court.
I understand that. Okay, so for the day visits, Dad's gonna be responsible for pickup and drop off. Once we move to weekends, I am gonna share that requirement. My hope would be there'd be agreement to meet somewhere in the middle, if at all possible, if not. And I will allow. Sorry, I can't. Miss Jeffers' client, Miss Vick, to choose whether she wants to be the pickup or the drop off on her end. So I expect Miss Jeffers and Miss Baldwin to hopefully have a discussion about that, and whatever Miss Vick chooses, I'll go with.
Okay, so she's going to choose prior to presentation, and then we'll just set it at that. Is that your order? Okay.
Yep.
I do want to clarify. Counsel's repeatedly said that the Adderall makes him not clean, and it's prescribed. The court doesn't have a concern. I just want to be 100% crystal clear that if he has prescription drugs, but they're prescribed, that does not count as a dirty UA or hair follicle, and that's not going to negate his visit.
As long as if it's a prescribed medication that he's taking as directed by his doctor, then no.
Great.
Yeah, obviously, if he gets prescribed things that he's not supposed to be driving on, then, we're obviously in a different situation, but I would hope that he would just follow the directives of his physician.
Great. Yep. Also, I want to clarify again the ability of my client to go to the child's games, sport practices, school events, that my client has authorization to do all of those things.
Ms. Jeffers, you didn't touch base on that any.
I didn't, Your Honor. My client doesn't have any contact with the father due to prior abuse. So that's always been her main concern. I mean, I believe that the request has been that he not approach her, those types of things, and he's not willing to comply. So that's where we are on that.
That's never been a request. It's just, you cannot go. My client has no desire to approach her or be with her. He just wants to be able to go to his child's events.
I'm going to authorize that, but I'm going to ask that Mr. Rance not have any interactions with mom, or try to avoid any. And then if there is a requirement for some interaction, that they be polite, neither party say anything disparaging or about the case, and the child is what should be the focus. But and I don't know if I'm assuming there's some kind of an app or website that will allow dad to gain access to what activities are happening without having to go through mom. So
he has access.
Okay. All right.
And then similarly, authorization to be able to access him and child can communicate via text and calls, video chats as desired.
And well, Your Honor, I would just ask that before he have free reign access to the child, we get a little bit further into the process to make sure everything's going okay. Certainly there have been concerns that father is highly manipulating the child, and mother has concerns about the amount of pressure that's being put on him. So, I mean, this is a guy he met 10 months ago.
So I'm not reserving on that. When overnights start, that'll be, I'll allow some phone communication. I'm not going to dictate how much or how often, but it needs to be reasonable. And frankly, if mom wants to review what those messages are about and there's any concerns, then that can be brought before the court. So father should be appropriate in these messages and should have nothing to do with visitations, time with him, unless they're planning some upcoming activity. But it shouldn't really have anything to do with the case before the court.
And then is the court generally adopting my proposed section 14? Those are sort of the boilerplate other play nice provisions. I think the only thing, this does include a prohibition against using corporal punishment. Requires communication by our family wizard, which the parties have already been doing for an extended period of time at this point. And it does include hair follicle provisions, UA testing provisions. In this case, because there are concerns both ways, it does allow both parties to test each other.
I didn't have any problems with those, but
I do. It puts a lot of, like, father's already hooked into the school as far as being able to get all the material that's sent to parents, but this puts a burden on mother to, she is obligated to provide copies of everything from the school that father already has access to. I don't think that that's appropriate. If father has access to the information, mother should be under no obligation. I'm just looking through them real quick, Your Honor.
Our only issue with that is there's a lot of things that get sent home that just aren't otherwise online. What's online is grades and attendance, what's missing in your grade book. But it might not be a notice for a disciplinary notice, might not be available.
Those are online now, at least at the school that he's currently attending.
School photo packets and simple things like that. Homecoming, things that just aren't going to be online.
He's 11.
Middle
No
school.
homecoming.
yeah, I'm not gonna adopt that portion at this point.
Okay.
And yeah, Your Honor, I guess that when we come back for presentation, I'll look at those, and if I have an objection, we should be able to review those very quickly.
Okay. Do you want to set that date now, or do you want to work together to set it?
No, we should set it. Let's go for a Friday, because I think that you said your schedule is booked for the next couple weeks.
Next week is judicial conference, and I think the 2nd is closed. So the next normal day is the 9th, unless Miss Wade tells me otherwise.
And I would like to go to the 9th, Your Honor, at this point.
I'm fine with the 9th, so long as the visits as ordered begin immediately.
And I would just ask to confer with my client. In other words, I don't know if they have plans for this weekend, but it should start with, if not this weekend, the following weekend. I can agree to that.
Well, and that was part of my order, that they should start as soon as possible, as long as there's not already. And that doesn't mean, just so we're clear, that does not mean that mom can go make plans today for this weekend. That's not, we're talking about long-standing plans before today. Otherwise, it should start as soon as possible. It sounds like everybody agrees to that.
Thank you, Your Honor.
Does the 9th work for you, Ms. Baldwin?
It does, thank you.
Okay. All right, so we'll set presentation for Tuesday, the 9th at 1.
All right, very good.
Thank you, Your Honor. Thank you, counsel.
Some objections and made some notes. So I don't know, I guess first I'd ask Ms. Jeffers if there's any objections that are agreed to, or there's any resolution to, or if we're just working straight off your proposed and Ms. Baldwin's objections.
Your Honor, I never received any response from Ms. Baldwin with regard to my objection, so I have to assume we're just working off my objections.
That's fine.
Okay.
There are one or two agreed.
Okay.
I just didn't have a chance to amend the order. So on her objection number 4, dates should be June 3 to 4. I agree. Similarly, her objection number 8, section 1404, as far as providing notification where you're away from home, I'm fine to strike that. That's just a boilerplate for me, but fine to strike that provision. So I think those were the only ones that were agreed. We can, I don't know who you want to hear from first. I know that you've looked at them. I can just kind of go through my little rebuttals and then you can make decisions, or if you want to go about it a different way.
Let's talk about the 191s. I know that there was an objection. Initially, I think my ruling was that I adopted anything that was in the previous order into this order. There was an objection on 3B and the substance abuse portion.
Right.
So I think I'm pretty aware of where Ms. Jeffers stands on that one. So Ms. Baldwin, if you want to respond.
Right. So on the section 3B, if you look at the guardian ad litem report on page 9, at page 9 says Ms. Vick reports that she was on oxycodone for 7 years. And then subsequently Ms. Vick states that she was an occasional user of drugs. So both of these parties do, per the guardian ad litem, have a substance abuse history. It's reasonable to have a finding that they both have a history. They've both been clean for a substantial amount of time now as well.
And Your Honor, this was not argued in front of the court. A prescription medication, Mr. Rance is on prescription medications right now. That would not meet the definition as far as I would argue to the court. In any event, your ruling was clear. It said that the findings that were made initially will remain. And I'm reading straight from the clerk notes and my own notes. The initial parenting plan, that factor only applies to Mr. Rance. Although he's argued this against mother several times, the court has never found it and it was not argued before your honor. Thank you.
All right, I'm gonna reserve, so I'm gonna strike that section. I'll indicate that it can be reserved, but in reviewing my notes in the minutes, I'm not making that finding at this point.
Yes,
The second paragraph.
So it's section 4, Your Honor, page 2, section 4 is my next objection.
Okay, sorry.
And I'm just going to say briefly, mother doesn't actually have a problem with this. It's just that father continues to push this. Mother's got this issue. Mother's got this issue when he's got the issue. And so it seems to imply that she's got the substance abuse issue. Otherwise, she doesn't have a problem with it. She's not a drug user.
I'm going to leave that language in. I don't think it implies that, and especially when we have the reserve of the 3B portion.
Okay, and the next is page 3 at the very top of 5A. This certainly was not anything that the court ruled on, and certainly I would argue that it's inappropriate. I mean, father gets the child on days that the child doesn't even have appointments. I don't want this gameplay where father makes a bunch of appointments without consulting mother and that type of thing. When it comes to the day-to-day appointments, you can make those when the child is in your care. Father's never made any of these appointments. So we just don't think that it's appropriate at this point, and especially not making all the decisions. If father's only known the child for 10 months, making all the decisions about what immunizations that he has and things like that. Just don't think it's appropriate.
So again, so we're looking at the top of page 3. This is standard language. If it's joint decision making, then both parents have the ability to schedule these types of things. My client doesn't have any intention of scheduling things on the mom's time. But again, it makes it clear that both parents also sort of have access to this information, that both parents are sort of, again, equal decision makers. So it doesn't allow anybody to make these decisions unilaterally. It just allows regular scheduling. I
fully understand mom's concern. There shouldn't be, and I'm happy to add this into order if parties think it's appropriate, but I don't think. So if dad has child, Friday evening to Sunday evening or Monday morning, dad shouldn't be making appointments for the child on Wednesday afternoon. Right. And I understand, especially if I don't tell mom about that appointment, mom misses that appointment, and then you say, hey, mom didn't take the kid to, a wellness child check, and then that looks bad. So I get the concern. I also understand, wanting the kind of equal opportunity here. So I would be willing to add the language if parties agree that, parents appointments are made during their own parenting time. Something that simple.
I have no objection to that.
And Your Honor, I would ask that the language also indicate with historical providers. Father lives, an hour and a half away in Oregon. So I don't want this argument over, oh, now he's got doctors down in Oregon and those are the doctors he needs to go to. The child's always had the same providers in the area. Father already has a release of information and is aware of this.
All right, so I've just included parents only make appointments during their parenting time with historical medical providers. I think if we want to add the language about not changing medical providers without an agreement between the parties, I can do that. I don't know if that's the best place to do that, or if that's just kind of an agreed understanding.
I'm fine with the language that Your Honor's put in. I think that that's sufficient.
All right.
I agree. This is an issue that we actually talked about on the record where father already has all electronic access to the child's records and things like that. So, we talked about the fact that because he's allowed access, mother shouldn't have to report to father. This is a case with domestic violence allegations, things like that. They can only communicate over My Family Wizard. And since he has access, we just ask that it be stricken. Again, we don't want this, son brought home an art project and because you didn't send it to father right now, you're in violation of the parenting plan.
So E is only as to school notices, not work, not schoolwork or, spelling assignments or those types of things. And I think everyone's aware that while grades and things like the standard school schedule may be posted online, there's a lot of things that come home that aren't accessible online. So my client is concerned that he'll miss out on the Veterans Day assembly and he'll miss out on, hey, there's basketball and here's the basketball schedule because those aren't available online. So his concern isn't for the things that are available readily online, but instead the things that are important to children that only come home through a handout or a flyer.
And again, Your Honor, those things are online 100%, as well as missed assignments, etc.
So here's the dilemma. I think as it's written, that could be seen as kind of an overwhelming burden potentially. But if you add in what's not available online, then one party's checking, okay, is this available online? So it just seems like a bit of a burden. That being said, I also understand that, there could be flyers sent home about certain activities that may or may not get on the website. I went just random side story, went to go check a friend of mine's baseball schedule at Kelso High School, and the baseball schedule was still 2021. So that's the concern I have. And I don't know that all schools do that or don't do that, I guess. So
I'm fine to add that aren't available online. If mom wants to sort of be the one that puts that piece of the burden on herself, that's fine by us.
And I guess I just say mom shouldn't be tasked with having to go and compare every single thing that comes home to what's online. I mean, the reality is kid isn't in extracurriculars or anything like that.
I understand that I think it is kind of a burden, but I am going to add that is not available on online. My hope would be that within a relatively short period of time, there'll be kind of knowledge of what's going to be readily updated on the website and maybe what's not. Okay, and then there was section M.
14K, Your Honor, which is
Okay.
on page 8. This provision, and I'm looking at my notes and the clerk notes right now, that provision only applies to father. I mean, I guess it's fine, but both parties can attend a child's events, but the court specifically said that father is not to interact with mother, and if it's necessary, to engage in that particular way.
So the court, if you look at the minutes, and then from my recollection, there was sort of this expressed concern. My client says, I just want to be able to attend. The court said, great, basically don't have contact, but hey, and my impression was to the both of you, everybody sort of be on your best behavior. And so my impression was sort of, yeah, dad can go. Yeah, dad should not make an effort to interact with her. But if it happens, you both are to be on your best behavior. So that's how I worded it.
Yeah, I'm fine with the language in K. I'll leave that.
And Your Honor, next is page 9, and that's going to be M2. At this point, the court has limited, contact to some degree between the father and child. Mother thinks it's highly inappropriate for father to want to be able to read all of the child's emails, personal emails, and things like that. I mean, they just started having visitation outside of reunification recently. So it seems inappropriate for father to have access to that information. unless the child wants to voluntarily give it to him, that's fine. That's what it is.
I reviewed this and I reviewed my notes. And here's what I'm going to do. I'm going to strike the first 2 sentences and I'm going to leave the last one. So either parent may restrict the child's access to social media or online content while they're in their home. I'm not going to require passwords exchanged. My hope would be that there's trust established that can happen. Mom may already have that, and hopefully dad, but at this point, I'm not inclined to grant that. But I do think it's appropriate if dad doesn't want child on Facebook for the entire weekend that they're together, that can be completely and totally limited by dad.
Thank you, Your Honor. The last issue is page 10, and that's going to be section P. As far as, I mean, the court never ordered that father can just start going for urine analysis and hair follicle tests on mother, and that she has to report to places within 2 days, etc. She doesn't have any history. And quite frankly, I don't even remember this being a ruling of the court. I can't find it in the notes, my notes. It was previously in place and we would indicate against father only, but this wasn't even argued.
So again, just going back to the same guardian ad litem report, they both have not a minor history with drugs. When mom says that she was on oxycodone for 7 years, that is not a small amount of time. This is sort of going back to Judge Worm's antenna theory. People tend to find like people. I think it's reasonable and in the child's best interest that both parents not be using.
Okay, I'm gonna make some changes to this portion. I have just historically some issues with some of this kind of boilerplate language that's often used. So I'm gonna have it include both parties. I'm gonna change the 2 hours to 6 hours. Change. Section 5, I frankly just hate altogether. If there's a positive alcohol test for an adult that may or may not have a significant problem with that, then I'm not going to have that terminate residential time. So if there's a positive drug test, then the parties can come to court. I'm not having the party's residential time immediately suspended. Then the matter may be set before the court, or the matter shall be set before the court as soon as possible. And then the remainder 6 through 9 would be not making any changes there.
Okay. Thank you, Your Honor. Thank you, counsel.
All right. And then Rance and Vic 20-3-00082-08. All right. Let me ask a question. Well, good afternoon, both of you. Sorry.
Good afternoon.
I saved you for last because it's kind of there's a lot going on.
Understandable.
So I have a modify temporary orders, an evaluation request, and then a moving and a prevent to move issue. So are those the 3 areas we're looking at today?
That's correct.
Yes, Your Honor.
Okay.
And Your Honor, I do have a preliminary motion to strike child hearsay, and I only address it now because your decision on it may limit our argument significantly.
I'm fine to take preliminary issues first if you want to, Your Honor.
I saw that, and sorry, I've been juggling a lot of different things. Can you point out, Ms. Jeffers, which index number you're referring to?
Index number. I'm going to have to get on Odyssey real quick, Your Honor. I am.
If you know what declaration or what it came, or whom it came from, I can look it up that way too.
It's a declaration of father filed in support of the motion to prevent relocation.
All right, one moment.
And tell me when you're ready for argument.
Okay, and that Ms. Baldwin, is that index 136? I don't know if you're on Odyssey. Filed 4/3/23. That's on right.
No, Your Honor, it's going to be filed 5/16/2023.
And I have a suggestion just to cut to the quick of the issue. And that is both
Okay.
parties used substantial amounts of child hearsay. I can point to declarations submitted by the respondent that are hearsay within hearsay. I think Your Honor knows how to deal with that pretty efficiently. And so given that, and given that both parties, if counsel wants to keep it out, great, but that keeps out entire declarations of hers.
And I disagree.
Again, Your Honor can, I think, make reasonable, otherwise we're gonna go line by line and spend a lot of time, because then my response is great, let's go through all these other declarations too, because there's hearsay and hearsay within hearsay.
And Your Honor, I disagree. Basically, this whole declaration is the child said this, and father argues that these statements are true. That is hearsay. The statements I attribute to the child in my declaration, we do not agree that they're true. They're not. They're absolutely not true. It was the fact that the child said it that was the point. It's not offered as the truth of the matter asserted. Father, his whole declaration and his whole basis for objection to relocation is based on statements he says that the child said, and he is saying that they're true. We
Okay.
disagree.
Is the I'm 99% sure I know what I'm going to do in this case. But I want to ask a clarifying question, specifically about the move. I think I'm able to determine what I should consider and what I should not consider. So I'm not going to consider any hearsay statements, regardless if they're from a child or otherwise. Where is, I understand it's Kath Lammett, correct, that the move is being requested to.
Yes.
And is there, is that to an apartment, a home? Because one of the declarations indicated it was an RV on property. So I just want to clarify where the intent to move. I don't need a specific address. I'm just asking what type of a residence will they be moving to?
And Your Honor, that is represented in the photos that father submitted. It's a manufactured home on acreage. It is 4 bedrooms, 2 baths. It is owned by mother's father. And the pictures of the RV and the debris, that's on the neighbor's property. It's not even related to the place in question. I don't know where the camper came from. There's no camper. It's a house.
Okay. The other question I have is, there's been kind of some reference to GAL. Do both parties agree a GAL is appropriate?
We agree to reappoint the GAL, Your Honor.
I agree.
And we
That's
would just ask that it be at father's expense.
And that's inappropriate.
Who did we have before? Ms. Corey, were you previously the GAL? Okay.
Yeah, that was me.
All right. And I did not look this up. I don't know how long ago you were discharged, and where you're going to need to, let's see. It looks like a report was filed late last year. So you're only about 6 or 7 months out of the loop here. Okay. That's good.
Actually, the attorneys and the parties have kept me in the loop pretty well. So
Oh, good.
I don't have much catching up to do.
That's excellent. Okay. So I'm gonna reappoint Miss Corey. And it sounds like she'll be able to hit the ground running. I'm gonna
You come in here or a conference room or?
I don't believe, let me just, looks like I have some proposed by Miss Baldwin. I have temporary order regarding relocation and a parenting plan from Miss Baldwin only.
And
I'm
I just left
assuming,
some big blanks in there too, just
okay,
so that you had space to craft as you wanted.
I just want to make sure that in Ms. Jeffers, you haven't proposed any orders or sent any originals at this point.
That's correct, Your Honor. I mean, at this point, I'm just requesting to go back to the previous order for, I mean, I think that Ms. Baldwin, since there's so many blanks on her proposed order, that will address the relocation issue. And I think she left a blank space if the court even wants to address the GAL issue in that. With regard to the other motion, you haven't got to it yet, and a proposed parenting plan. I usually wait for decisions on that. If you prefer that I send that in advance, just let me know and I'll be sure to do so in the future.
I don't necessarily have a preference. I just was making sure I had everything in front of me that I was supposed to have. So
Okay.
I'm going to apportion the GAL payment the same as the temporary order of child support. So proportional pay. And here's where I'm at. So there is a lot of back and forth between these parties in these declarations. There's a lot of concerns that the court has. Frankly, I think everyone's being a bit ridiculous. There's a scar left from
21 p.m.
Mr. Rance's time that he spent in prison. Frankly, I don't even know what the underlying charges on that were, but clearly that is impacting Miss Vick. And I think moving forward, the parties need to try to focus on how that can be minimized for any impact on the child with this child's safety and well-being in place. So frankly, at this point, let me see. I always think I make excellent notes for myself, and then there's like little gaps so I know that we have parenting plan schedule in place. So
It's not happening though. So my client's now being denied.
So, let me finish. I did notice, and I will ask for some input on this. It did appear as though the reference to me saying keep the counselor in the loop effectively eliminated a visitation or has eliminated some visitations. Is that?
I disagree. This is so when you're ready, I can argue more fully on that, but it is not Mrs. Rosen's fault that visits are being denied.
I'm not claiming Miss Rosen's fault, but it sounds like since there wasn't a meeting when mom set a meeting, then is that why visitation stopped?
No, Your Honor, and this doesn't really need to be argued. What happened is the child expressed some issues with visitation. He went to Miss Rosen. Miss Rosen recommended that the pickup for the exchange for the next visitation be in her office so she can discuss those issues. Father and child, Miss Rosen, were all present for that meeting, and Miss Rosen was unable to convince the child to leave with father. That's what happened.
And we would dispute. Essentially, we had visits that were going fine. There was the objection to the relocation filed. Suddenly, visits are not going fine. And suddenly the child is expressing, if you look in the materials that are filed, Ms. Rosen never says there's a problem with my client. She says child's making disclosures. Both parents are telling Ms. Rosen things, and Ms. Rosen is sort of saying, I don't know what's real and what's not real. And the child isn't expressing any of those things to her. So those are not, that's essentially what her email states. So then we have a situation where then child's not going with my client, even though that's the court order. And I think we're sort of using Ms. Rosen as an excuse that mother is still taking child away or not driving away. It's a situation where it's my client is not being allowed to parent. And if your honor's ready for further argument, I think Miss Rosen's own letter is the best reference you have for this. So Miss Rosen's letter.
Is that the February letter?
Yeah, that's a February letter, Your Honor. And I
Okay.
just indicate that the email for Miss Rosen.
Okay, stop. I'm not changing the parenting plan. It's
Right.
staying how it is. Period. I'm appointing a GAL. Child needs to remain in counseling. If he has any issues with any of this moving forward, that's his resource. As far as concerns with the move, I understand dad is opposed to the move. I'm not, I'm going to grant a temporary move. I'm not going to, and then I guess if the parties agree to change the pickup location, I believe it's currently in Ridgefield.
Woodland.
Is it Woodland? Okay. If there's an agreement to change that, fine. Otherwise, it remains in Woodland. And then I guess we just need to set a date for when we want any additional information from Miss Corey.
That's fine, Your Honor. And I would just ask for some guidance. I mean, do you want my client to just have the child dropped off at the Safeway and just leave him there? Because right now he, according to Miss Rosin's email, he refuses to go. And mother's not even the one providing transportation. He's been left by a family friend at the Miss Rosin's office so that she can facilitate the transfer and convince him to go, and it's not working. So if the court says that my client needs to have him dropped off at a location in Woodland at a Safeway and just leave him there, that's what'll happen. But I need clarification because father's going to claim this is all mother when the child says, I don't want to go.
This is the problem, unfortunately, with the gamesmanship that's happening. My client, because of the allegations, he's kind of like, I'm not going to touch anybody kind of a situation. So he's not going to open anybody's car door because mom's going to immediately claim domestic violence. She did that previously. In this case, like during the pendency of the current action, as far as if he does anything, and the pleadings that she has in the court file now are, he look at his behavior. So my client's being super careful and reasonably so. This is a situation where the people that are dropping the child off all have a vested interest in the visitation not working. So it's all people that mother claims essentially are co-parents with her. It's either her live-in boyfriend or the ex-boyfriend who she claims has the child every other weekend. So these are all people with a vested interest in this not going well. And I think that inherently is part of the problem is we have these people who are not going to encourage the child to really get out of the car. It's kind of like, gee, kid, if you want to go, you can go. But that child's in an impossible situation where to do so, he's biting the hand that feeds him. He's biting essentially his mother's hand, and that's his only house right now. And so that child doesn't have a lot of options. So in this case, that's my significant concern for the child. I would ask that the mother have someone drop the child off who frankly she can't drive, so it won't be her, or she doesn't have a driver's license, and that it not be her current boyfriend, who we've have concerns regarding domestic violence with, or the alleged sort of stepfather, her prior boyfriend. Again, they all have some weird vested interests in this not going well.
And I disagree, Your Honor. I just asked, Ms. Baldwin, are you asking that the child be dropped off in Woodland and left there? If that's what you want, that is what will happen.
Okay, so you're wanting me to say, yeah, leave a 12-year-old child all by themselves at a Safeway in the middle of wherever that's nowhere that they have family that lives. That's unreasonable. Here's the thing. We're adults. Are we not adults? These individuals are adults. They have children. They need to figure this out. If they want me to dictate every single moment of their lives, hey, I'm happy to do that. We'll set a full day and I'll do that. But they need to step up, act like adults. This child has two parents, and this man has a right to be involved. He's not done he's gone through a year of reunification counseling with no issues, mind you. And now all of a sudden, there's all these things that are coming out that frankly don't have a lot of basis. I am concerned that these folks can't figure out how to exchange a child so a dad can get a few hours a week with him. That's concerning.
I understand, Your Honor. Even the counselor couldn't figure it out. So I'm not sure what to do here.
I don't want the child to be placed in an unsafe situation. I don't want him left if dad isn't there. If the parties agree that we try Miss Rosen's office for the next couple exchanges,
Agreed.
but I don't, it shouldn't mean that the kid doesn't get to do the visitation and dad gets missed out on the visitation.
Here's what I
But-
propose. I don't want the child I don't want to create a game where the child's encouraged to run either. That's not a good solution. What I probably propose in this situation is the court order drop off to begin the other person's time, which is sort of the reverse of what we usually do, but that require essentially mother's designee drop off at my client's address. My client will drop off at mother's address. It's a rural property. Essentially you can drop off at the end of the driveway. You have the pictures, so there shouldn't be any issues there. He doesn't have to drive up the driveway. He can literally pop the kid out on like the side of the road. But that sort of resolves the problem, because then child's being left at a home on both sides. It's not my preference as far as it's not ideal, but I think that's honestly the best solution, because what the request is, let's go back to Rosen, that's already failed twice. So that's not working. I think that we're using that now as a method of validating a missed visit, instead of it being a problem solving solution. At some point, we've done that for a year. That's not the right solution. I think there's a lot going on in the background for this kid. So that's, I think, a reasonable solution that will effectuate the visits you've ordered, and sort of require both parents to effectively transfer the child without the gamesmanship.
And I kind of disagree on that one, Your Honor. That's just a long round trip for either party, quite frankly. And I don't know how that prevents anything, quite frankly. If the child's not going to get into father's car, he's not going to walk into father's house.
Then dad'll have to deal with that.
I think the concern is, so it's very weird from my perspective, obviously, and likely yours, since we're all outsiders to these folks' situation. We're not accompanying them to these drop-offs and pickups. When a child essentially refuses to attend a visitation, it is a ripe situation for one of the parties to claim bad actions by the other. And it slices both ways. So Mr. Rance could make the claim against Miss Vick, or whomever the misters are that have been ferrying the child to pickups, and vice versa. Frankly, given the current state, I don't know that I can dictate who Miss Vick, if Miss Vick doesn't drive, she's in a predicament where she's relying on other parties. I'm not going to dictate who she gets to do these transfers. I am going to, and I want it in the order that Mr. Rance is allowed to open the car door. So I want the exchanges to happen where they're supposed to happen. The child's not to be left without the other party present and accepting that child. Mr. Rance can open the car door and ask the child to come with them without there being any issues. If the child, frankly, I'm not going to sit here and decide what's going to happen based on what the child's response to that is. If the child refuses and Mr. Rance as a parent picks the child up and puts him in his car, I'm not saying that's an automatic contempt. There should, there's reasonable parenting involved there. Children, unfortunately, don't always get to dictate when and where they go. That's especially true in situations where there's multiple parents and they don't live together. But Mr. Ranch should be allowed to do that. Conversely, Miss Vic should be allowed to do that if child isn't wanting to get out of the car when Mr. Rance drops off.
And Your Honor, I would just ask that instead of opening up the door, my client will have the child out of the car. That's not an issue. I mean, he is getting out already and going to father. That's not a problem. Instead of dad randomly walking up to people's cars and opening up their
Then
door.
why are we even having this discussion? I thought you said the child's not refusing to go. Was that just because it was at Miss Rosin's office?
Yeah, we haven't tried this outside of Miss Rosin. Miss Rosin was going to help facilitate the transfer to dad. So it was just Miss Rosin, the child, and dad.
Okay, well, let's, I guess then I'm not going to try to solve a problem that doesn't exist yet. So transfers in Woodland.
And I would just be, they should be clear, if they kick us out of the car, the other person needs to drive away. Why are there? We should not be creating.
As long as dad is there. I mean,
yeah, sure.
Yeah.
Yeah, absolutely. Yeah. It's just the idea that we're sort of like literally like putting the puppy between two people and leaving both car doors open. It's like.
No, I was under the impression that this was happening beyond at Miss Rosin's office. If it's
No.
child's willing to go with dad and get out of the car, then there shouldn't be an issue. But the child shouldn't be left unattended at the Woodland Safeway. Okay, so, and then frankly, if the parties agree to change the location to the McMenamins and Kalama or whatever, based on the move to Cathlamet, I'm fine with that, but I'm not gonna change it unless it's agreed by the parties. All right, any, I guess, Miss Corey, since you're clearly there's a lot of turmoil in this case, you're relatively up to date. How, and this is going, I guess I'm asking all three of you, do we want to set a GAL? Do we want to just do a final? Do we want an interim?
I would like an interim. We were supposed to be kind of doing that anyway. I'm trying to remember now if we have a date in August or if we were going to set one. So I would ask that we have something out in August. The idea is that if originally when you set this calendar, it was kind of like if there's any time left in the summer and we don't know if there will be, then we could note it back on to address some more extended time. So we kind of had that, if not the idea, if not an actual date, we had the idea of having it pinned back in anyway in August. So that would be kind of my thought. If Ms. Corey doesn't have a final done by that time, that's certainly reasonable. But I think input at that time is reasonable because at that point we would have sort of completed the schedule that you've laid out.
Okay, so we have August 1/8/15.
I'm out the first week of August.
I am also.
Okay. So August, the first full week of August or just?
First full week, Your Honor.
So the 15th of August, would that work for everyone?
That's fine.
That works for me.
Okay, so we'll set the review for August 15th at 1 p.m. Sorry, go ahead, Miss Corey.
Can I clarify then? You're looking for a final review in August or an interim review in August? Final review if it's done, and if not, an interim? Did I understand you correctly, Ms. Baldwin?
That's my understanding. Obviously if it's done, fantastic. But if it's not, there's a lot of allegations. And we're also dealing now with the relocation. And so you're tasked with all of those things. So that's not giving you a whole lot of time. It's only giving you really a month-ish to get all of that information done. So my guess is you'll only have an interim done by that point.
That would be my guess too. And could the order appointing maybe have some specific points, issues that the current issues that we're looking at detailed, please? I don't know which one of you is doing
Well,
it.
that's a great question because it just, frankly, it seems like everything's at issue at this point. There's domestic violence back and forth, accusations is by respondent to petitioner, and petitioner alleging that between respondent and other domestic partners. There's issues with the child in school, but arguably a new
So-
school would be started with the move. So there's a
Would it be fair to say that just looking at pleadings since my report?
I think
would-
probably even especially since, frankly, there's been a boatload since April. I think April forward. And then I know that there was a request for an evaluation by respondent of petitioner. And what I will say is I'm going to authorize the GAL to make any requests for evaluations of either party as part of the investigation.
Without bringing that back to court or?
Correct.
Okay.
Is Your Honor putting a dollar limit on those though?
Yeah, I think Miss Corey, my hope would be that she would be not asking for a full, psychosexual polygraph examination, those, $3,500 things that take, 9 months to get done. So within reason. So if it's something other than a standard DV eval or standard SUD eval or, something along those lines, I guess I'd want you to bring that back before the court.
Okay.
And so then I'm going to call it an interim GAL review for August 15th at, hold on. Yes, August 15th at 1 p.m. If the orders are, if we have agreed orders, great. Otherwise, I don't know if you want to set a presentation for orders. My next week I have very little on next Tuesday for some reason. And then I have Fridays at 8:45.
For Friday, I'm not available next week, but I am available Friday. We could either do this Friday or next Friday. Both are
Can't
fine.
do Fridays, Your Honor, until at least July 14th for me.
Let's see, I could do the 27th. I just can't do next week.
Let's take a look. I can do the 27th as well. And just to clarify orders, I'm going to, Your Honor, you have the relocation order. So you need an order, the GAL order. Is that it?
I need a GAL order. I guess I don't know if the parenting plan that, I guess that you're in agreement with the parenting plan that Ms. Baldwin proposed.
There's
No,
you said
didn't
you said the current parenting plan, Your Honor. So I'm assuming we're sticking with the current parenting plan.
We already have one of those entered?
Oh,
Yes.
yeah.
Sorry, I moved to the 27th to look. The 27th is currently closed.
Take us to July 11. I can do July 11.
I can do July 11 as well. And I mean, also, Your Honor, I mean, if you just want Ms. Baldwin to prepare the GAL orders, I'm totally fine with just sending you written objections and have you enter the order as you see fit.
If Ms. Baldwin agrees with that, I'm happy to do it that way. And then we don't have to set a review other than the August.
That's fine.
Okay.
So,
And then the temporary order of moving was from Ms. Baldwin, and I don't. And all the language is
denial.
a denial. So I don't know.
Okay, she sent me something else that was blank. So I assume that was what it was.
No, it is, but it's denied, and then there's big blanks in it for other relief. So that's the same order the judge is looking at.
If you want to do the same process for that,
Yes.
if you can't agree on it, then I'm happy to just do those ex parte once I receive everything.
Perfect. And just procedurally, my suggestion is that Ms. Jeffers and I'll just consolidate all of those, and once we have them, we will send them to you as like a bundle, so you don't have to guess on whether or not you have it all. You'll just get them as a packet.
That sounds fair.
That's fine.
So I will shred the 2 proposed that you sent, Ms. Baldwin, and await the bundle.
Yes.
Thank you, Your Honor. Thank you.
All right.
Counsel.
Thank you all. See you August 15th. GAL report review of temporary orders today, and then also to set a final written GAL report date today. So where are we at, Ms. Corey?
So I have had the opportunity to speak with both parents as well as meet with Jaden twice. And this is a very angry young man. I believe that and I am concerned that he's feeling like he's really in the middle of this conflict between his parents. And I also believe that and am concerned that he may be hearing people in both households speak poorly of the other parent. And I did want to remind them about that. I think it's imperative that Jaden get counseling immediately. The last time I met with him, he told me that he had gone once, but his mom said he didn't have to go back again. So I think that needs a little oomph behind it. And I'm going to withhold, I think, for right now, any other recommendation beyond the counseling. But perhaps dialing back the visitation schedule at this point might be a good idea. So to maybe 1 full weekend a month, 1 full weekend day, rather than, I believe we're at 3 or first, third, and fifth weekends, but just dialing it back a bit, kind of give Jaden some breathing space. And I know I'm kind of dumping this on the attorneys right now, and I apologize.
I'm ready when Your Honor is ready for argument.
Sure, go ahead, Ms. Baldwin.
So the court has to, and this case has been pending for a long time. It was filed in 2020 when my client was incarcerated. He was released in the summer of 2021, did everything to get his ducks in a row, filed a motion to resume visits because they were not willingly resumed in the fall, late fall of 2021. Again, after getting a job, getting things in line, so he could sort of prove to the court that this was not some flash in the pan. He's been doing, from there were multiple hearings where we had to force mom to do reunification counseling, where the court had to say, you have to actually set an appointment, finally get reunification going late, or not late, but into the spring of 2022. We do reunification counseling essentially for a year. We're coming to the end of 2022. During that period of time, Ms. Rosen was working with the family. Visits were expanding under essentially her authorization and her understanding that she could expand visits. Visits, by all accounts, were going extremely well. Mother then got a new attorney, was told, hey, you don't have to expand visits. So they went from a planned overnight snowboarding trip to, hey, here's your 2 hours supervised. From there, visits started taking. And so then we go from doing really well in December of 2022 to being ratcheted back into these 2 hour supervised visits with Ms. Rosen. And then if the court will recall, then child was refusing to go entirely, to where the court then had to most recently say, you have to send the child. It's not acceptable to not allow the child to just decline. And most recently, we had child running directly from mother's car to McDonald's, where he called 911 and essentially was expecting 911 to intervene and not require the visit. This reeks of alienation. It just does. Mothers never wanted to reunify the child. Child's now been told you don't have to go to counseling. You don't have to do the things the court's ordered you to do. Hey, let's go run into a business and call 911 to frustrate the visit. The child's in the middle because the mother's putting him there. My client wants a relationship with this child. At this point, we have spent 2 years getting to a point of having normalized visitation. The idea that we reward mother by ratcheting back and reward her behavior doesn't make any sense. The only way child is going to get to a place of peace is if the court is clear that you can't do this to the child. These are the visits. This is what we're doing. We are moving forward. This idea that we're going to kind of just allow the cycle to continue is not appropriate for the child, and certainly not in this young man's best interests. Again, real concerns in this case. The court recently made orders regarding relocation. Again, in this case, I don't envy the guardian ad litem in this case. I think she has a very difficult job. But my request is the visits stay the same. Mother is required to call and get the child into counseling today, full stop. The idea that she can just say, you don't have to go, you don't have to do this anymore. Again, it's rewarding. We're creating a system where we're rewarding that behavior, both in child and in mother. That's not appropriate. So I think that we continue the visits, allow the guardian ad litem additional time. I think a reasonable amount of time is 3 months. I know that's a long period of time for the guardian ad litem, but because of the dynamics of the case, I think the guardian ad litem needs more time. And the reality of, even if mother's required to call today to get the child in, it doesn't mean the child's seen today. And to get records, to get any kind of relationship development records from that counselor, that just takes time. So I would put this case back on for a final review, essentially towards the end of the year. I think that that's a reasonable course of action, but we should not reduce visits. Mother should be required to get child into counseling and provide proof to the court that that's happened. And we should also set a review to ensure that, for the sole purpose of ensuring that that happens, because given the track record of this case, it won't happen absent a review.
So, question to anyone. Sorry, excuse me. Child was seeing Miss Rosen. That's when we were last here on the 13th of June, and that's stopped now?
They were using her for reunification counseling. So I guess I don't know if Ms. Corey is thinking reunification or more of a personal counselor.
I am definitely thinking of more of a personal counselor. I believe that the reunification counseling has ran its course, and that Jaden would be very resistant to going back there.
I don't disagree.
Ms. Jeffers?
Your Honor, father seems to keep saying because it was a rough road at the beginning that mother should be punished forever. It was a rough road at the beginning because father was incarcerated so long for violent crimes, and there was some legitimate fears. The reality is that excuse me. The reality is that mother's been doing what the court has said. The child refused to go. The court, we talked about this at length on the record about when father's there, leaving the child. That's what mother has been doing. And there's certainly no allegations that she hasn't. So there can't be any, allegations that mother's alienating. That's just not correct. She's been forcing the visits. Additionally, she went and got the child his own counselor. Last time I knew, he was still in counseling. I don't have any knowledge to the contrary. And it certainly wasn't her position that he should just stop counseling. He's had some real issues with what's been going on. There's been a lot of police involvement, nothing to do with mother. Mother's already left the child by the time that occurs. The visits themselves have been going terribly. I believe as recently as this last weekend, father sending the child messages that say, you're doing bad in school. You will be punished your whole visitation. You could expect to stay in a room and not do anything fun. And the child is acting out. It's not going well. I think that he does need to go to counseling, and we should see what the counselor has to say. Mother's supportive of the visitation. She's going to do what the court says to do. And certainly if there's anybody in her household talking bad about father, that's going to be addressed immediately, because she wants this to go forward. She wants her kid to be okay. And the reality is he hasn't been since this visitation has started. And I believe that's the basis of the recommendation of the GAL. If we're having a child that's reacting this negatively, not just in not wanting to go, but acting out in school, acting out in destructive behaviors that he has never engaged in the past, I think that there should be okay, let's find out what's going on and let's see how we fix this. So I would ask the court I don't have a problem with the counseling. don't have the problem. Neither parent should be talking poorly about the other in the presence of the child or allow third parties to do so. Absolutely agreed, 100%. But I do know that there's a lot of problems with the visitation. And I think it's more important that the visitations start going well than we just keep forcing the issue with more and more backlash from the child. Thank you, Your Honor.
Thank you, Ms. Jeffers. Ms. Corey, do you, anything else you want to add?
I don't think so.
Ms. Jeffers, is the 90 days for a final GAL report suggested by Ms. Baldwin, does that sound fair to you?
I think that's fine, Your Honor.
All right, and Ms. Baldwin, any final comments?
My only concern are, the visits are going poorly. You can't say that mother's in compliance when it's, I'll drop you off, but with instructions to call 911. It's not going, that's not compliance. It's just not. You're setting up the child for failure. You're setting up visits for failure. That's harm to the child. We have to get to a place where mother is not creating this negativity.
All right, here's what I want to do. I guess I have general concerns. Clearly there's two very different versions of what's going on here. I do recall 7 months ago, 8 months ago, maybe not even that long ago, we were at a really good place with visitations. And they weren't supervised. They weren't, as far as I recall, not professionally supervised. And things were progressing well. And then mom did stop a planned trip and things were ratcheted back from there. And there was a request, I think, to move, and a whole bunch of things happened sort of over the ensuing several months after that. Why things are all of a sudden not going well, whether that's the mom intervening in a negative way or things really being that negative at dad's house. I don't know that the court can make a decision on that. What I am very concerned about is the child's well-being, because clearly something's going on. And frankly, it could be completely unrelated to any of this other than he's, caught in the middle. So I think we need to get him engaged in a personal counselor as quickly as possible. That's going to be the number one most important thing. Both parents should have access to that counselor as far as to if the counselor wants to inquire of them, not necessarily to provide information to the parents about what child's saying, but to allow the parents to express what they're observing or what their concerns may be. And I want that to happen as quickly as possible. I understand that we may be able to make an appointment soon, but that appointment may not happen soon. So I am gonna, are the parties available on in 2 weeks on the 29th?
I can be, Your Honor. And
So
I'm pretty sure we can get a quick counseling appointment. He's already got a counselor and has started.
Okay.
Whether that's continued, I don't know, but we'll get that going if it hasn't.
All right. So here's what I want to have happen. I am going to put a short stay on visitations. Let's focus on counseling. I'd like a report back on the 29th. So in 2 weeks, of just some insight, and with barring any extreme concerns from counselor, with the intent of getting visitation restarted. And even if that's reconfiguring what that looks like, on the 29th. But between now and the 29th, I don't know if phone or FaceTime visits or anything like that have been happening. If parties are comfortable with that. Also, no disparaging comments by parents to the child or any other adult or individuals in the parent's presence to the child about the other parent will be allowed. I will set the 90-day review. Does November 14th work for everyone?
I am currently scheduled to be in a trial the 14th and 15th, Your Honor.
All right. I think I'm out the following. So the 7th of November.
Yeah, my
That
preference
works
is the
perfectly.
7th.
All right. So Ms. Corey, does the 7th of November work for you?
It actually does not. I have 2 trials that week.
Oh,
Well, but I would ask that we just maintain the 7th. Guardian items aren't generally necessary for the entire trial. And so my thought is she should be able to come over and handle this matter if that's necessary.
All right. Yeah, we'll keep November 7th, and then everybody can just keep everybody appraised of their schedules. So November 7th, 1:00 PM for final GAL report. And then update from counseling to the court, the 29th at 1.
Yes, Your Honor. I just want to, as far as filing with the counselor, an absolute deadline, because that's obviously 2 weeks. I'm not sure when the last appointment took place. I can try to get an immediate letter, but what's your cutoff? Because I just anticipate I'm just going to be filing from the counselor. Is that the court's anticipation as well?
I think at this point, yes.
Okay.
And if that stems other issues and responses needed, then obviously we can have a review prior to that November date.
Last day to submit that?
Ms. Baldwin, you want to weigh in on that, or?
I mean, it is what it is. The court at this point is terminating my client's visitation after 2 years of effort from him. This is incredibly discouraging for him. So for him, this is challenging. He doesn't want to delay anything. File at the hour before. We want to go forward. If we're in this position where we're terminating visits until we get a report, that motivates one side to delay. And that's kind of the inherent problems where we've terminated visits in the interim.
And I have no intention, Your Honor. I just need a cutoff date so I can move on that quickly.
Is the most up-to-date information that we can get is fine. And if that is an email to all of us the morning of the 28th with the most recent information and filed later, then that's fine with me.
Okay. Done deal.
And just so, sorry, I was looking at the wrong month.
29th.
Next month is it's the 29th, sorry. So the morning of the 29th, I misspoke. And as I stated, I understand it's, I'm sure Mr. Rance feels like he's always the one bearing the brunt of the issues here. And, I'm sorry for that, but the child's well-being is, and the concerns that have been raised, that's where we're at. But this hopefully will only be a very short period of time. So we'll review the 29th at 1 p.m.
So before we move on though, I do have specific requests. My client has zero information about this counselor that we are now being informed at docket has been selected and the child is seeing. The counselor's name, address, phone number should be provided today by end of business. Similarly, mothers should sign all releases for my client to be able to communicate with that counselor again by end of business today or tomorrow. My concern here is the court's authorized my client to have access to provide information, but without my client knowing who that person is, that's impossible to do. So these are kind of the inherent concerns that my client has. And additionally, if the court's ordering visits with the counselor, those visits should be required to be consistent and regular, such that the child's actually getting therapeutic value. My concern is the child's seen the person once. We'll see them once before your order today, and then won't see them again. And that's not my understanding of your order.
Your Honor, I think we can deal with a lot of these issues. The GAL has the counselor's information. I have no problem with her providing it. I don't know whether I'll be able to talk to my client today. But, these are kind of what the kid is going through. It's like these demands that you do this right now, you do this right now. The father's actually doing to the child. This is part of the problem. Of course, I will provide that information to opposing counsel. The counselor will be informed that father can give input if the counselor wants it. The last thing I want is the child trying to establish trust with this counselor and father putting an immense amount of pressure on the counselor. Why don't we see where the child's at and then see what orders are appropriate?
The request is that we hide the counselor, despite that's not what your Honor specifically ordered.
Well, and I'm looking at our most recent temporary parenting plan, and it's joint decision making across the board, and that information should have been provided to the father already. So I am going to authorize that release, and since so it needs to be to Miss Baldwin by the close of business on the 16th. The name, address, phone number, the counselor, and an ROI needs to be done no later than close of business on the 17th.
I actually do not have the name of that counselor.
Okay.
So it should just go to both of us. And then is the court ordering regular visits? So this isn't a one-off.
Yes, this should be, this child is exhibiting concerns that I think need to be regularly discussed with the counselor. Obviously, after continued visits and the counselor says, okay, that's fine, but I don't know that we're there yet. And I haven't gotten anything to show that we're there yet. So yes, these should be regular appointments, whether that's weekly, every other week. Obviously, the counselor, I hope, would make that determination based on the need and availability. But they should be regular, ongoing appointments as needed.
And if I could ask for an ROI for me also for the counselor.
That's fair.
No objection.
All right. Anything else on this matter today?
No,
No,
I'll try
That is my time. Okay, Rance and Vic. Ms. Baldwin beat everybody to the punch here. So we are here on a review hearing.
Yes, so two things. We're here to review ensuring that the guardian ad litem report had been filed, and second, to address the current restraining order. So the court had entered a temporary restraining order and sent it over to today to essentially review that in light of sort of the guardian ad litem as well as the child being in counseling. And if the court will recall, we were not with the guardian ad litem report. Guardian ad litem's on board. So the court will recall the last time we were in front of the court, the court had some concerns about the visits and how visits were going. The court paused essentially father's visits for 2 weeks, set things over in this case to review and review father's visits, ordered the child to get into counseling. So a couple things that were filed, both parties submitted declarations, and then sort of last minute, there are two filings. One is the filing from the mother filing some documents from Columbia Wellness. I don't know when that was filed. It was signed the 27th. We submitted today, additionally, essentially a copy of the information we received. So at the last hearing 2 weeks ago, the court ordered the counselor's information to be provided essentially immediately. And we provided you the email that we got from opposing counsel. So where we are is we've paused visits and we're here to review what we're doing here today. Concern here is child's not seen father now for 2 weeks. So my client, we've been doing a long reunification process. The court will recall this case started in February of 2020. We've been pending essentially 3.5 years at this point. The record shows in July, based on what was submitted by opposing counsel, that unilaterally, without any joint decision-making or discussions with my client, and contrary to court order, the respondent mother takes the child to a counselor. My client doesn't even know this is happening. Counselor provides her report that's submitted here. Of course, we never see this until now, until it's provided just now. The counselor says, well, I've called father, he didn't respond. My client didn't even know this was happening. We don't know what number, if any, was provided to the counselor. So again, real challenges there on, and even if a random call from Columbia Wellness comes in from my client and he gets a voicemail, why would he respond to it? In the sense of, how would it be relevant if you just get this random call from somebody that it's not in counseling to my client's knowledge? Then we move forward. We have the court orders the counselor's information to be provided and for the child to be placed back into counseling, essentially. We have the email that they've submitted essentially saying child doesn't meet the qualifications to continue counseling. So no, we're not going to do that. Concern here is that the information provided to my client that he would have reached out to was a completely different name than what the actual counselor's name was. The name that we were provided with was Bethany Pollard, not Stephanie Pollard. Those are two very different names. The spellings of the last name are even different. So again, we're provided the incorrect name, incorrect email to a counselor that's been engaged over a year, or not a year ago, been engaged more than a month prior, that my client had no knowledge even existed. So again, the idea that my client can even try to connect with a counselor, it's impossible. This is just further obstruction. And again, the court has to recall where we were. Back in December, child and Mr. Had been working with Charlotte Rosen for approximately a year. Visits were going really well. Visits had been expanded by Charlotte Rosen. They were doing these visits where they'd meet at her office and then sort of off they go for the day, come back. No reported issues from anyone, not Mrs., not Mr., not the professional reunification counselor. Everything's going well. Charlotte says we need to expand to overnights. Everyone agrees. Mrs. then says, no, ratchet it all back, 2 hours in the office, completely supervised. Again, then it takes my client time and funds to be able to get back into court. Meanwhile, Mrs. files to relocate. My client objects. Suddenly, child's visits are going terribly when the court expands my client's visits. So we go from a child that's doing fine and having great visits to a child that's angry, that is reacting poorly, that's running from my client and calling 911. And the clear indications from 911 are that child's being coached. We have my clients being able to hear mother directly coaching child.
I'm going to object, Your Honor. This isn't in the record. We're here to review counseling records. I think every time we're in court, we go through 2 years of history.
We're here to review the pause, and that includes all of it. So the court paused. It wasn't just, hey, is he in counseling? The court paused and suspended my client's visits. We're here to decide what we do for visits going forward. So all of it is very relevant.
That is not my understanding, Your Honor. Your ruling was very clear. Child to see a counselor, file the counseling records. We come here for a review.
I disagree. You said we'll get information, we'll come back, but and you said I'm not just going to leave this paused. Counsel wants to act like, hey, you paused it permanently. Don't even consider anything. Just, confirm the kids in counseling and move along. That is not what we were doing.
That's not true. I'm deferring.
My notes indicate and the minutes indicate that I did a 2-week pause on visitation to get an updated information on counseling, and that the hearing on 8/29/23 would be to review those counseling records and set visitation moving forward. So go ahead, Ms. Baldwin.
Thank you. So we see suddenly these visits where, again, my client can overhear mother coaching child. Well, didn't you tell 911 this? Well, then if they don't do what you want, then tell your grandma this. Call these people, tell them to do this. My client can overhear her on the phone. So this isn't a he said, she said, or hearsay. My client directly heard opposing parties say these things to child. And frankly, Mrs. doesn't dispute it. She doesn't deny it, that this is what she's doing. That has to be viewed also in light of the motion to compel that's been filed. And that's one of the reasons why my client wanted that to be considered, not in the sense of you're going to make a ruling on that, but in the sense of the phone is being used as a tool to manipulate the child. And that Mrs. is using that to alienate the child from father. It's, I didn't get what I want. I'm mad that these visits are going forward. Let me continue to obstruct using the child's cell phone, because these are the direct records that they're refusing to provide, which are the records that would indicate exactly the extent of the interference by mother. Again, we see the records from Stephanie Pollard, and even if you look at those, what is child saying? Child, a month ago, essentially when all this was supposedly blowing up, dad isn't coming into the fact that his dad's coming into my life is not causing the issue. This is the direct words from child to counselor. Dad isn't the problem. Child denies anxiety, basically says, hey, these weekends are interfering with some of the things I want to do. And otherwise, this doesn't have anything to do with dad, his family, anything dad says, does. So there is nothing in that record that's been filed that indicates any wrongdoing on my client's part. So again, a significant concern here. It's also concerning that essentially mom co-ops that visit. If you look at the paragraphs of what they filed from Ms. Pollard, it's essentially kids going to do the intake, but mom says, no, 13-year-old can't do it alone. I'm going to come in and I'm going to tell you what the problem is. Then counselor meets with child, and child basically denies, says, no, that's not what's going on. I got into a fight because I was defending another kid, not because something's wrong with dad and me. When child denies the problem, mom then comes in a second time being like, no, this is really the issue. So mom's clearly trying to sort of push her agenda on counselor. I'm concerned because counselor says essentially she validates mom, which I think is like, oh, you're right, kind of a thing. But again, there's nothing there that supports continued suspension for my client. The concern here is we have Charlotte Rosen for a year. So we do have the professional reports of Charlotte Rosen, all of which are positive. Dad's on track. There are no concerns with dad. There are concerns with mom that Charlotte Rosen specifically calls out saying, hey, I do have some concerns on what's going on with mom, but for every hoop, dotted every I, crossed every T. Meanwhile, child isn't doing so well with mom. When we look at mother, who has the child 99% of the time, child's missing school, child's getting into fights. We have domestic violence in the mother's household with a police report to verify that. We have her relocation to a mobile home in Cathlamet. We have her not working, no evidence her significant other is working. So we have 2 adults with no clear income coming in. We see really chaos in mother's home. But all his mom does is just go back to the same well of let's blame dad, must be his fault. Hey, he's a felon. Gee, he does drugs, but doesn't provide any evidence of this. Like my client says, yep, I committed that felony, paid for it, turned my life around, doing all the right things. There's already an order that mom can drug test my client at any time. And the only time she's done so, my client went and did it, and then she refused to pay, even though it's a loser pays order. And we, in fact, had to hold her essentially in contempt for that and order a judgment to get her to pay it. What we do see in this case is obstruction. We see 3.5 years of obstruction of her saying, when my client was incarcerated, you can't even send letters to this kid, even if mom could have opened them and looked at them and read them. I refuse for you to even have that level of contact. For my client has done everything to fight his way back, take parenting classes, first aid classes, AED classes, become a supervisor, go out, get a job, be working, completing probation, literally doing everything possible that this court has asked him to do just to be in his child's life. And what we see on the other side is repeated contempts, repeated compels, repeated orders to comply over and over and over again for 3.5 years. It is not reasonable. I understand the court giving a parent grace periodically and saying, hey, maybe you didn't sort of get up to speed fast enough. But after 3.5 years, that has to come to an end. There has to be an end. It has to be an end for this child. We started this case and this was a 10, 11-year-old child, and now he's 13, 14 years old. We're looking at a kid who's going into high school, and it's just not reasonable to continue the path we've taken and to allow this repeated behavior with mom just saying, I'll just obstruct. It works for me. Don't really get held to account for it. It's not reasonable. So my client, again, is not being unreasonable. He's not asking you to switch custody. He's not asking for you to sort of do something dramatic. It's basically asking you to stick to the order you already made, that at this point in time, my client should be exercising his visitations Friday to Sunday. Second, we're asking that the child's phone not go with him. The child's phone is being used as a tool for alienation and allows mom to just repeatedly peck at that child the father's entire visit. That is not appropriate. It's not working for the child. At this point, given his age, he can self-help if he needs to. He can use any phone that's laying out, any iPad that's laying out to call 911 if that was the situation. But that's not what's happening. What we have is a child and a mother who are using that phone to alienate. So no phone on the visits. My client is asking for fees. This is a situation where my client is somebody who struggles. It's very hard to come out from incarceration. He's done an amazing job, and much to his credit of sort of pulling himself up by his bootstraps and doing all the right things. But when you look at it, and it's important to look at that pattern, and I didn't even go through all of it. I mean, counsel sort of doesn't like the recitation. She doesn't like it because it's bad for client. Because when you go through that long history of contempt, compel, requiring mom to comply, when you look at the history in a totality, it's really, really negative for mother. And it's very clear that she's alienating and obstructing. She just doesn't want this to happen. And the reality is that at some point we need to have regular visitation. And at 3.5 years, that time is now. So again, we're asking the court to essentially just hold to the order that you already made. We need to just go straight to the regular visit pattern. But again, with the caveat of the phone shouldn't go, with the caveat of these are reasonable, because when you look at the totality, it's the mother here that's obstructing.
Right. Ms. Jeffers.
Oh, Your Honor, I kind of feel like I'm in the twilight zone here. Basically, Ms. Baldwin just argued a motion that's supposed to be in front of you in 2 weeks that we haven't even got a chance to respond to yet. This is characteristic of father in this case. He says, bad mother, bad mother, bad mother. But the reality is this isn't about mother. It's not even about father. It's about the child. And that's something that father seems to always forget. Father says, give me fees because visitation was suspended. Keep in mind, mother didn't ask that visitation be suspended. This was a GAL recommendation that neither party knew what the GAL was going to say. It's absolutely ridiculous to say this is all mother's fault when this is based on the investigation of a GAL, a neutral GAL that the court appointed because these allegations of alienation and things like that were going back and forth. And the court said, okay, bring the GAL in. And neither party knew what the GAL was going to say. All right. This was the recommendation of the GAL. The reality of the situation, if counsel wants to argue from their own material that our response is being filed as I speak, the visitations have been going horrible with father. That is the reality of the situation. There's no question that the child's behavior has escalated, and it escalated when the visitation started taking place in father's home. Yes, supervised visitation is going well. I would submit to the court that if it was still supervised visitation, it would still be going well. But we have gone through this again and again, what was going on at father's house. He attempted to alienate the child from not only mother, but the other family members, and it backfired on him grossly. This is a 13-year-old child, and father indicated that he was talking to this child about blowjobs and drugs. It's just absolutely ridiculous to say, oh, this is all mom. This is all mom. Mother did what the court said, asked for guidance and said, look, he's not going. I've used Charlotte. She can't get him to go. And the court said, drop him off and drive away. And that's exactly what mother did. And he has gone on all of those visitations. So I deny that mother denies that she was on the phone and all this weird stuff. The reality is that the child's having problems. The child won't speak to anyone about these, won't speak to a counselor. That's the problem with the counselor. The child just says, I'm powerless here. It doesn't matter. I can't do anything about this. So I just try to get through the time at father's as I can. According to father's own filings, again, visitation is going horribly. The child's not engaging. There's destructive behavior at father's house. This has nothing to do with mother. This has to do with the interactions between father and the child in father's care, and father believing that he was going to get full custody of the child if he could just have the child say all these bad things about mom, and it backfired on him. Mother immediately identified that there was a problem going on with the child. She went to get him to into counseling. They indicate maybe an adjustment disorder, but the child is shut down. I mean, mother is deferring to the recommendation of the GAL at this point, because child is shut down about it. Mother didn't know if the child was actually even going to talk to the GAL, because even as close as mother and child are now, he is completely shut down. He just says, I can't, I'm powerless. As far as the phone, mother thinks it's ridiculous that this is before the court. Father is a parent, taking a phone away from a child is in the discretion of the parent. So she doesn't even know why there needs to be a court order. If there's something wrong with the phone, then father needs to be a parent and take the phone away. At this point, things are so bad in his household, really, that don't know what good it's going to do, but that's his prerogative. And she's certainly not going to interfere with that. So that's basically where we are. We're deferring to the GAL. The GAL was kind of didn't really want to say a lot. It appeared at the last hearing about what was disclosed by the child, other than that he's very angry. We know from the counseling records that he's refusing to engage and talk to anyone. He feels absolutely powerless, and mother is doing what she's supposed to do. She is getting him there. If that is what the court orders, that's what she'll do. It's just so ridiculous that we keep coming back to mother's so terrible. Mother's so terrible. Again, who cares about the parents? All mom cares about is this child, and this child is having a very bad reaction. That's one of the reasons for the GAL, and mother is deferring to her. Thank you, Your Honor.
Thank you, Ms. Jeffers. Ms. Corey, I am going to ask if there is any information or any response or anything that you want to provide at this point, and then I'll turn back to Ms. Baldwin.
Well, I've actually seen some positive things in this case recently. I believe that Jaden being in a smaller school is going to be quite helpful to him. And although Columbia Wellness declined to get him started in therapy, Ms. Vick has sought out a counselor that's out in Cal Flamet that she hopes to get him started with. I'm not clear whether that was at the school through one of the programs or whether that's a private counselor. I'm not clear on. Also, I just learned that these parents have spoken with each other. And one of the most significant things that I learned from Jaden is his anger is stemming from his parents not being able to even talk to each other. And he is in the middle. He's had significant life changes in the past, 6 months to a year, including the move to Cal Flamet, including the difficulties with his father, the trouble he has been in school. And I think it's a lot for him. I've seen evidence of alienation on both sides. And the fact that the parents have spoken with each other, trying to maybe work things out together, that speaks volumes to me based on where they were when this case started. It was, I didn't expect them to ever speak. So I was actually kind of pleased to hear that. But that's all the information I have at this point. One of the attorneys mentioned that it is difficult to get information out of Jaden, and that is very, very true. And I've spoken with him since my reappointment twice, met with him twice, and really all that's coming through is his anger, and anger at both of his parents, really. And that we're still here after 2.5, 3 years, whatever it has been, that he is ready for it to be done.
Thank you, Ms. Corey. I appreciate it. Ms. Baldwin?
Thank you. I think that's just it. Kid's tired of being in litigation, and I don't blame him. I think sometimes we sit high and mighty over kids, and they get frustrated because despite Ms. Corey's involvement and counselors, at some point, kids are done. And this kid's made it pretty clear he's done with Rosen, he's done with counseling, just wants it to be set. But it also is pretty clear that mom doesn't, because these folks were cruising towards that quickly in December, and that was 100% derailed by mom and mom alone. And we know that from Charlotte Rosen, because Charlotte Rosen was moving forward. Everything was hunky-dory, no negative reports whatsoever reported from mom, from Charlotte, or my client back in December. And that was that same period of time where then mother just said, oh, I learned I don't have to do what you want, so I'll ratchet back. So it's mom who's put child in this position of just kind of ripping him back and forth and then saying, oh, well, I'll wait for the court to decide. I'll make the court to decide. And that's not appropriate as a parent. That's not putting your child first. That's not putting your child in a position to succeed. Again, when you look at the record, the child's voice to Ms. Pullard is specifically that record says he described how his dad coming into his life was not causing any of the issues. So that's not it. Mr. is my client, father is not the reason. Again, I have big concerns here where the report from Ms. Corey is, oh, and by the way, there's a new counselor getting on board. Once again, where's joint decision making? Where is the information being provided that we're doing this? It's not that my client is going to say no. My client would generally agree to counseling, but the idea that that the mother can just unilaterally do that despite the court's order for joint decision making does speak volumes into her opinion of sort of her control over, I can control and dictate. And that's really what she's done. And that's what we've seen over and over and over again. Counsel saying, oh, and Mr. talks to him about all these horrible things. Where is that in the record? Where is there any evidence of that is admissible evidence? There is not a shred. It's just kind of these random things that they'll throw out where there's just not a lick of evidence behind it. And all of what my client puts before the court is like, here's the record, here's the statement, here's what I can provide. And so father provides all of that and has for 3.5 years. This kid needs it to be done. My client needs it to be done. We need to just move on to the parenting plan Your Honor already ordered. That's reasonable. So again, I'm asking that the court comply with the order that you already set forth, which would put us at this point in time on regular Friday to Sunday visits. Second, the phone should stay with mom. Counsel saying, oh, make dad the bad guy. That's not fair, because mom says there's no evidence she even called the child. You know what proves that? Phone records. You know what we've asked for? Phone records. So that's one of those things that can't have it both ways. And that's what they're trying to do. Mom should be required to keep the phone with her. And if there's somebody to blame, I guess mom can blame it on the court. But that's reasonable to prevent that type of alienation from continuing. And finally, the fees that we've asked for, they're not due to the GAL. They're not due to the father's time being suspended 2 weeks ago, despite no evidence of wrongdoing on his part. That's because when you look at the record, the pattern of obstruction is clear, including the most recent pattern of obstruction of not providing the counselor's name, even though that was a direct order from Your Honor, sort of a do it right now, and they still didn't do it. So it's those types of things over and over and over again that when you add them up is a pattern of obstruction. That's what the fees are for.
All right.
Your Honor, I feel like I should get to address this. It's not like Ms. Baldwin is the moving party who should get more airtime here.
Okay, briefly.
Okay, so with regard to the counselor, the court was very clear that mother needed to get this kid to a counselor. That's what she did. Okay, so to now say that that was in bad faith is just not true.
I think it sounds like there's a whole new counselor, not Ms. Pollard. Is that correct, Ms. Corey? That there's a new counselor local in Wahkiakum?
Well, mother's looking for one.
I wasn't sure whether she said she had one or that that was her intention. I thought she said that she did have one out there in the local area.
So I can tell you that the child is set to meet with Miss Pollard on September 6th to see about counseling options. So that's what I know. As far as a resolution, mother actually called father to see if they could come to an agreement. So to say that, you know, mother is trying to prevent that from happening just isn't true. I have that evidence that will be filed today for the court's review. With regard to the phone records, I do have them. Unfortunately, I have been in trial and arbitration and have not had the chance to review them. The discovery request right now is not just between child and mother, it's between every person in human history, pretty much forever. So the ability to review all those, I haven't had time to do so. We'll address that in the motion to compel. And quite frankly, attorney fees, any obstruction acts that the court felt mother did, she was already punished for through attorney fees. Father's just trying to financially break her. He actually makes 3 times more than she does. And it's inappropriate because he didn't like the GAL recommendation. Thank you, Your Honor.
Some of the concerns that I have about this case, it's obviously pretty contentious. The child clearly is caught in the middle. I think there's some animosity, resentment, and this is all just kind of my outsider perspective. Clearly, dad left mom in the lurch at a time when he was needed and could have been a pivotal person in her and the child's life. And so there probably is some leftover from that. Dad has tried his best to fix that situation as much as you can, and is now trying to repair the relationship with the child and has worked hard to do that. And through reunification with Miss Rosen, and jumped through most of the hoops that the courts required of him thus far. We did enter May 9th, I think, May 9th, 2023. There was a temporary parenting plan that was entered that mom was primary. This was before the move. But mom was primary and decision-making was all joint, and essentially was set up to start. There was some summer visitation schedule in there, but beginning August 1st, so moving into the school year, father to have every first, third, fifth weekend from Friday at 5 to Sunday at 7. And then there was an agreed holiday schedule for essentially the summer holidays with Thanksgiving, Thanksgiving break and winter break, and any 3 or 4 day weekends not listed as reserved. So that was entered. And then within a couple weeks, we had a motion to modify and basically start from scratch. And so we've not been, that plan never really had a opportunity to take flight, so to speak. I understand concerns that the parties have. I just am a little concerned because I don't, there's a lot of one-upsmanship here. Well, mom's the one who called dad to talk it out. Okay, I don't care. The fact that they talked is great. We should be encouraging that and not like putting brownie points on one side versus the other, to be very frank. The fact that they're willing to do this, and especially since Ms. Corey's input from the child is that he just wants his parents to be able to just coexist reasonably. That doesn't mean they have to be best friends. That doesn't mean they have to hang out. That means that he can have a peaceful existence in each of their homes and not have to worry about any of this. That's kind of what it sounds like to me, to be very frank. I'm glad to hear that being in a smaller community and maybe in a smaller school will benefit him. And so that part of, the decision for the moves pretty much was done, and we're where we're at. So I'm happy to hear that. What I'd like to, I reviewed sorry, I'm scrolling through Odyssey here. I reviewed the information that Ms. Jeffers filed yesterday. I got that this morning. I reviewed everything, and I think it's appropriate for, assuming he's willing to engage, for the child to have access to a counselor. I guess my personal opinion is, forcing therapy on children doesn't necessarily do any good if they're not willing to engage. But I think having the access to somebody that he is comfortable with is extremely important, because you never know when the child's going to want to actually reach out and utilize that individual. So I think that's great. I do think mom and dad should discuss that together. I did see I think it's one of the last pages Ms. Jeffers submitted was that there's a intake appointment for the 6th of September at 9 a.m. for the child in this case. So whether she can remain or if that's someone that the child's willing to engage with, I guess is to be determined, but I think there needs to be a counselor available to the child. I think we're in a situation where, as much as I'm concerned, the parties should not be speaking disparaging of one another. They should not be discussing this case at all with one another, or with the child, excuse me. I misspoke, with the child. So no disparaging comments to the child of each other, no discussing the case or any other adult topics with the child. I want to reinstate the May 9th parenting plan. And as I stated, I do want the child to have an opportunity to have a counselor that they can reach out to. I understand the request for the phone, but I'm not going to, this kid's gone through a lot. I understand that the concerns with mom reaching out repeatedly to the child by phone. Let's have the phone go with the child. Mom only to contact the child if in an emergent situation. And if dad needs to limit contact or limit phone usage during his parenting time, then he needs to limit phone usage during his parenting time. And I'm not going to authorize any attorney's fees. So I know that the parenting plan from the 9th, as I scroll back to it, indicates that it is the first, third, and fifth weekend defined by the first Friday of the month. I don't know where that puts us. I would assume the attorneys could determine that for any exchanges upcoming. And it does appear that we're here next or in 2 weeks on the 12th for a motion to compel. Is what I show.
Yeah, so we're probably going to be back in 3 weeks on a motion for a protective order.
I'm glad you're so enthusiastically optimistic about this, Ms. Jeffers. I don't know. I'm concerned about attorney attitudes impacting the client's positions on this case as well, to be very frank. So if you and Ms. Baldwin don't get along or completely disagree about this case, I'm worried that that's impacting your clients. I'm concerned about that. So I don't know that we need to enter another order since that parenting plan was entered May 9th. If we want to, if we have any presentation of any orders, we can set that for the 12th, if that works for the parties.
That works, just because I think everything you ordered is already part of the May 9th, except the limit on mother can only contact child via the phone, like essentially in an emergency. So I think that's really the only difference, but I think that still should be reduced to an order. Additionally, I just want to make it clear, we don't have any objection to Stephanie Bullard. The child's already met her once, that's fine. But if a new counselor is being chosen, then that needs to involve both parents. And so we just want to make that clear. It's not, again, my client's not against counseling. He's 100% on board and in favor of it. But he wants that to be a joint decision on who's being selected.
There is joint decision making on that. So that is appropriate. If it's Ms. Pollard, then that's great. If she's available to continue being accessible to the child moving forward.
And I don't think that's the case, Your Honor. I think she's meeting with him to try to determine who a good counselor will be for him. It was her recommendation that he might do better with a male counselor.
Okay. Well, then, as long as that information is shared to all the parties, then any updates, any names that she suggests, anything like that, I think we just need to try to get these folks to see if they can work together without the assistance of counsel. That would be great. So we'll set this to any presentation to the 12th, and we'll see you back in 2 weeks.
All right, very good.
And Vic 20-3-0008208.
That matter's ready. Good afternoon, Your Honor.
Good afternoon. How are you?
Good.
And good afternoon. Can the court hear me all right?
I can.
Okay, thank you. I'm just having a problem with my video, but otherwise I'm present.
Okay. All right. So I have presentation of order and a motion to compel that we're on for, and I do have proposed orders, an order on hearing from August 29th and an order compelling answer to discovery. So those two orders I've been provided with. I did not see if we start with that order from the order on hearing from August 29th. I didn't see any written objections. Ms. Jeffers, any concerns with this order being entered?
I don't know what order you have in front of you, Your Honor. I signed, excuse me, I signed an agreed order that was supposed to go to the court, but I can't see what you're looking at. I don't know if that's it.
So I believe that Ms. Jeffers did sign off on the form of the order and we sent it over. We would have sent prior to her signing both orders in preparation for today over. But I believe Ms. Jeffers has already signed that order. So I would just not do the presentation and that order will just get signed in due course. It might have just been in the ex parte box since it was agreed.
Okay. So the order on hearing that I was provided for August 29th, 2023, I will set aside, assuming that there's an agreed order that's coming or may have already been signed by a judicial officer. Okay, so then we're just on for the motion to compel this.
Yes.
All right.
So in this matter, we have filed a motion to compel in this matter and filed a relatively lengthy declaration attached to that. We did provide sort of point by point the specific requests and the objections that were the result of the CR26I. We filed that. The vast majority of the objections that were made were not valid. They just simply were not valid. They are not legal objections. And so at this point, the response was essentially at some point or by now, counsel stating that she would have filed a motion for protective order. I have not seen that. That is certainly not docketed. And so where we sit today is just the reality of these materials need to be provided. I think there is significant frustration in a lot of the materials that were requested are clearly not privileged, are clearly relevant. There was admissions to their relevance and still refusals to provide that necessitated the motion to compel. I think that's frustrating, especially in a case like this has gone on so long when you have materials that are relevant and one side sort of is repeatedly blockading. And I think that the history of the case is somewhat relevant when we look at this very long-term reunification that's gone on, a case that's really been pending now for quite some time. And one party just repeatedly sort of doing everything possible to throw up roadblocks towards completion. And so that's certainly frustrating. It's not appropriate in this matter, and it's causing undue delay and undue prejudice to my client and not being able to prove his case and not being able to move the case forward. And the reality is the child suffers. The child suffers when we delay and we don't get cases completed. In this case, I am asking the courts to order the materials to be provided. There's no valid objections that have been provided. The court should across the board say provide the materials that are requested. The court should set a due date for when those will be provided. The court should set fees and the court should set sanctions. Fees should be substantial. And I think a sanction is appropriate given the fact that the objections just simply weren't valid. Second, I will relay to the court that this morning, at what is most assuredly the 12th, 11th hour, I did receive some materials from Ms. Jeffers' client. There remains objections where they're still saying we object. Those objections remain not valid. Some of the objections are, well, Mr. can obtain these himself. That's not a legal objection. So again, we sort of remain in the same position. So I would ask the courts to enter the order to compel, award fees and sanctions in this matter. It's appropriate. It is reasonable to do so. And the materials that are requested are very relevant. We did our best to time limit them to reasonable time periods, essentially from focusing really on the pendency of this case. If the court wants to time limit some of the other requests, fine for the court to do that. But that really wasn't even their response. Their response is just a generalized, we're going to file a motion for a protective order. So I think our request is pretty straightforward. We'd ask the court to grant it.
Ms. Jeffers.
So, Your Honor, the 26I was requested by me for the purpose of a protective order. That's all we discussed. We didn't discuss what material I had, what I didn't have, when I'd be able to review it, or a due date. Otherwise, council would have been aware of my litigation obligations. At this point, we talked about some scope, discovery. I did provide some discovery within that scope, and mother had the discovery to me. The problem is there's too much to review. Google, Facebook, basically there's no limit on time or scope. It goes back a significant amount of time. Every video watched, every place where navigation was ever used, every search ever conducted. It is significant. And the reason that the protection order has not been requested at this point is because some of the information is also privileged. Until I go through all of that information, I can't bring a motion, an effective motion for a protective order. And it is significant. I anticipate the protection order once I review the completed materials, but I have been in extensive litigation over the last month that has prevented the time necessary when we're talking about, again, information starting when Google started, basically. And quite frankly, some of the information may need to be subject to a subpoena based on my contact with some of the phone companies and things like that, and the date ranges that they're able to provide. So at this point, that's where we are.
Very briefly,
Yes.
that's none of what council said is a reason to not provide. So privileged materials, that's what a privilege log is for. That's very straightforward. But none of the materials of the child's are privileged whatsoever. That child doesn't have any privilege. There's none to assert, and mother can't assert for him. Counsel's assertion that, well, gee, maybe there's some stuff we have to subpoena. That means they don't know yet. They haven't even attempted to obtain those materials yet. So as we sit now, they've not gotten them. They've not attempted to get them. It's just, well, I'll get to it when I get to it. The purpose of a CR 26I is to go over the interrogatories and requests for production and try to make agreements on what will be provided and what won't be. When counsel just generally makes blanket, I'm not going to provide it, there's no point in me setting a date. Yeah, I don't have to set a date for something counsel says I'm not going to do. That's the purpose of the compel. So it's reasonable to come forward then with a motion to compel when counsel says I'm not giving it to you regardless of the date you set. So the purpose of the 26I is simply, it's a meet and confer about discovery. So as we sit now, counsel's not telling you what she has, when she'll get it, when it was requested, none of those things. They have an obligation to this case that has been pending for a long time to move it forward. And the objections raised are not valid. There's no protective order filed as we stand, and no real valid reasons why a protective order would be issued. If there's privilege in the materials, counsel can file her privilege log along with the materials that she provides.
And I just will say, Your Honor, that I provided the child's information to opposing counsel. So I'm not quite sure where she's going with that.
Okay, so I'm reviewing some of the requests that are laid out, at least in the motion to compel. Some of them, I see a lot of them have 3 years since January 1st, 2021. 3 years since January 1st, 2021, since January 1st, 2022, not since the beginning of Google. So I'm going to grant the request for the motion to compel. I am going to give you more than 10 days, since sounds like you've been in trial extensively recently. So I'm going to give you I'm going to give you 20 days from today. And I don't like doing it, but I will impose a $500 sanction and $500 in attorney's fees. I know that's drastically lower than what's requested. That's what I'm willing to order at this point. So I've signed off on that, and I do not. We have a final review for GAL November 7th. I don't know if we need anything else set in the meantime.
I would just ask that we just add into the order to compel that we'll review it at that same time. I'm fine with the November That's 20 days and essentially 20 more for us to suss out anything that sort of remains. But I don't want to just leave it without a review. Some folks argue that there needs to then be additional motions. My client shouldn't have to pay for additional motions to be filed.
Well, and Your Honor, I'm still going to have to bring a motion for a protection order. That's where it is.
Okay, I've included that this will be reviewed no later than November 7th, 2023 at 1 p.m. So
Okay.
if the protective order happens before then and needs to be noted on, then it'll need to be noted on.
Thank you, Your Honor. Thank you,
All right,
counsel.
thank you. Good luck. Ranson Vic 20-3008208.
Matter's ready.
It's ready, Your Honor.
All right, we are here for something. Hold on.
Motion for protective.
Correct. Motion for protective order based on discovery requests. And I have. Odyssey is like, this is the worst
So that's
time.
fine. I didn't file a reply. My reply is really just argument. So I'm just prepared to make argument and go through essentially her arguments and dispel them and dispatch them in argument.
And I'd object to that, Your Honor. Washington is a pleading state. If there was an objection, it should have been put in writing.
That's not required. If it's just based on the law, I don't have to file a memo. I would need to file pleadings if I had factual statements to make. And there's previous pleadings directly on point on this issue and declarations that have previously been filed. I don't have to regurgitate those. So I'm prepared to go forward. Again, these are really straightforward issues. Counsel's arguments generally just fail on the merits.
All right, hold on. Let me. Here we go. I'm sorry. Odyssey has just all of a sudden decided to not cooperate with me. So just let me.
It's been bad the last couple of days.
Motion for protective order that was filed on the 26th lists out the specific request for production that you have concerns with. And I've reviewed all of those. So, and I did make notes. Let me grab. So specifically, we have request for production 1, 3, 5, and 6. Is that correct? Is that just those 4?
Yes.
There's
That's
4,
fine.
yes.
Okay. Okay. Ms. Jeffers, do you want to make any additional argument?
I don't think so, Your Honor. A lot of stuff has already been turned over to opposing counsel, but specifically with regard to mother, social media, and Google, we want to start limiting the amount of information. I'm also awaiting subpoenas for text messages between the parties. At this point, I think I'm over 35 hours just reviewing the initial stuff. This is a basic parenting plan case. This isn't a civil fraud case out of New York, and the parties both have very limited resources. Additionally, at this point, a lot of it is not relevant. It's overbroad with regards to the social media and Google. There's no time limit. It's from the beginning of time, and that's just not appropriate. So we are asking for a limitation on that. There's some really big concerns here as far as information on other children, their locations, where they go to school, their schedules, things like that. There's medical information about other children. And not only is that not relevant, but it's pretty scary to hand that over to somebody who has been convicted of multiple violent felonies. The tracking information is also problematic. Information requested is location of where mother is every time she accesses her phone, things like that. I don't know that that's relevant, especially going back as far as it did. And given the domestic violence concerns, there's serious concerns about how that information would be used by father. The other, basically kind of 1 and 3 go together, the same arguments, and then 5 and 6. With regard to 5 and 6, this is text messaging, mother and child. You know, at the 26I, we talked about just limiting the communications between mother and child. I haven't heard anything from opposing counsel yet on that. That's what we're trying to do. The court has previously ruled that father doesn't just get access to the child's everything. Specifically, that argument came with regard to Facebook. So we've already turned over the communications between mother and father. I did submit some information on messages that father has sent to child, and there are concerns of how father is going to use these. As you can see from the messages, you know, it's basically, I'm going to punish you, your life is not going to be happy, those kinds of things. It's a very significant power and control dynamic that's going on with father as regard to the son. And the child's already, the GAL has testified, is having a horrible time in this situation, and is acting out, is shutting down. And again, there's concerns on how that information would be used. There's also concerns, again, these are messages with, some of those messages are with other children. And information with regard to those children, their addresses, where they like to hang out, stuff like that. I'm not sure how that is relevant to this case. And again, I think it's too overly broad. Again, location information, where the child is at every time. But I mean, those are the major issues, Your Honor. We're just asking to limit the time to, say, 1 year. I think previously it was 2021. I can see what I can do there. Limit the tracking and location data, the information regarding other children, limit the communications between mother and child. That's appropriate. And I think that will do it. Thank you, Your Honor.
Thank you. And I'm just going to state for the record quickly, Ms. Baldwin, then I'll turn it over to you. So request for production number 1 is a complete archive of social media accounts. And these are the ones that are at issue. Number 3 is archive of Google account, except email, including name or in which you have access, including digital copies of account history and archives. Number 5 at issue is, oops, I skipped over it. Where did number 5 go? Oh, there it is.
It's at the bottom, page 3.
Electronic native copy of information available on each page of Jaden's text messaging and her instant messaging services from January 1, 2021. And then number 6 is electronic native copy of text messages and instant messages from, I think, Miss Vic from January 1, 2021 to present. So I just wanted that on the record. Ms. Baldwin, go ahead.
Thank you. That's fair. So you really have to go through. So first, discovery is broad. It's very clear under the court rules that discovery is designed to be broad. And the only way you can limit discovery is if it's done for some improper purpose. They don't allege that. They don't allege that at all. The second, you could have that if it's unduly burdensome, and they don't get to that either. So when we look at things like request for production number 3 and request for production number 1, which are essentially downloads, this is not the Exxon Valdez in the 1980s, where I'm asking for a truckload of printed documents to be delivered to my office. It's a link that you click, and then you download it, and then you put it in a Dropbox. It's a 5-minute process. Nothing on there is privileged. So if it's not privileged, it's discoverable. And in this case, they even admit that it's relevant. And so again, their arguments fail. They say, well, not everything in there is relevant. Relevance is not a bar to discovery. And they straight out admit that some of it is relevant. So if it's relevant and it's not asked for an improper purpose, and you can't show that it's unduly burdensome, you have to provide it. It's very clear. Again, this is broad discovery. Counsel like, oh, I've spent hours and hours going through this stuff. That's her choice. And that'll be my choice on what I go through and what technology I use to glean through that information. But it's not required because it's not like she's going through it to create a privilege log. Nothing in there is privileged, especially with the social media and the Google logs. And that's why we intentionally excluded the email. I didn't want even a chance that I would accidentally happen upon an email that would be privileged. So we've excluded everything that's privileged. So all that's left is stuff that's relevant that they admit is relevant. Again, they say directly, not all of it is relevant. And I'm sure that's true, probably all discovery I ask for. Not every page of the ream of bank records is relevant. It just isn't. But some of it's very relevant to the case. And that's what we're looking for. So again, their arguments fail there. Then they make these very weird fictive arguments about other people may have some concerns. They don't list any individual person by name. There is not one of those people who's come forth today. There's not a single declaration of a person saying that they're concerned or afraid. So this is just mother casting the specter of, gee, maybe some information that other people might be concerned about might get out. But again, this is all things that they've put on social media. These are all things that they have broadcasted to the world. At some point, you can't really complain when you've put that forth to the world. Again, costs, there's no cost affidavit and fee affidavits here about time that has been spent. And arguably, when we're talking about a link that you download the material and you send it because nothing in there is privileged, it isn't costly. You're choosing to go through all of it, and that's fine. But the procurement of it is not costly. And that is the question. It's not how much it costs them to go through it. It's the procurement is the question. The next sort of specter they raise is he'll use it to track her. There's no evidence this has occurred. There's no evidence this has occurred essentially since my client was convicted, spent time in custody, he's gotten out. He's done everything he can to stay away from her. The only evidence that they say exists is there's been a photo of her home. And I will tell the court that the single photo of where mom lives in Cathlamet was done by my investigator, not Mr. Rance. So again, we have this specter of he'll misuse it, but no evidence he has at any point in this case done anything to track her whatsoever. When we look again to the text messages, and I'll tell the court, I did not time limit the Facebook and the Google because I think it's harder to time limit it with the link than it is to just say, send it all. So I actually tried to make it easier. If the court wants to put a time limit on it, that's fine. I think I offered to put a time limit on it in our CR26I. I made multiple offers across the board to try to solve this problem. And that's part of my declaration that's previously filed. I said, we'll put a time limit on it. How about it's only accessible to me and my staff, and my client can't even look at it. None of those answers were accepted. So again, when I tried to solve the problem, offer time limits, all rejected. So again, there's no real excuse as to why they haven't provided this other than it's negative for them. Next, we get into the text messaging. The text messaging is critical. They themselves use text messages to prove their point. So they're fully admitting they're relevant, fully admitting that they're useful for the purposes of litigation, but they say, but don't make us provide them because that would be bad. But there's no evidence whatsoever that it's asked for an improper purpose, that it's harassment. Those are specifically time limited to the time period where this case has been in litigation. So again, we're really dialed into the time period where my client's been asking for time with his child. So we're asking essentially for mom's text messages, specifically with child, mom and dad's or child and Mr's text messages, and mom's text messages to the broader world, child's text messages. These will give us the scope of who is feeding information to this child, who is sort of swaying the child one way or the other. Counsel sort of makes the argument that children are swayable. I agree, they certainly are. And these text messages are the types of things that will give us that information. And the native format is important because the information that they use is completely undated. We don't know when it was, how it happened. So again, you're getting sort of this mishmash of, well, this is when she says it happened, but no one's really quite sure. So again, that's relevant. They admit it's relevant. They just don't want to provide it. So again, the reality here is that it needs to be provided. They raise essentially, it's a lot of cut and paste through each of these of sort of raising these same specters. The argument does not change. So again, we've done our best to limit it time-wise, limit it as when appropriate. But again, these are not things they're even being asked to print out. And the things they've provided, they haven't printed out. They've provided to me on thumb drives. They could provide it to me in Dropbox. So again, really straightforward and simple. So again, I'm fine if the court wants to add timelines to some of the social media and the Google accounts, that's fine. All the rest of it, I believe, is time limited to 2021 and forward. This is a situation where the court should deny the motion and award fees for me being here today, especially in the case where there's my declaration where I offered all of these solutions to these problems, and it was just, no, I'm not going to do it. That's not reasonable. Parents have a right to pursue their case, and especially when you have some information that's clearly extremely relevant, which is mom's text messages to child, what she's telling him during these visits.
Thank you. Anything else, Ms. Jeffers?
Yes, Your Honor, I don't remember any of those statements being in her declaration, so I guess I'll defer to the court's memory on that. In any event, it looks like we are in agreement that her client cannot review the discovery. We're agreed then on time limits. And it sounds like we're agreed that the text messaging will be between mother and child. Is that correct, counsel?
No, those are things I offer to try to solve the problem before getting here. I think my client should be able to review it. I don't think it's reasonable. If the court wants to limit it, you can't take it out of my office, that's fine. Again, I was making every effort to find any solution, and that is part of my declaration previously, but my client should be able to review the information with me. He's not going to be able to remember, like if the concern is tracking or something of that nature, he's not going to be able to remember a bunch of GPS coordinates when he leaves my office. It's just not a reasonable fear. It has to be reasonable. The argument isn't.
And Your Honor, that's kind of one of the issues that we're having here is during the 26I, these were agreements. And then it's like, oh no, that's not the agreement anymore. And I bring an emotion is brought saying, oh, sorry, there's no agreements. It's getting ridiculous at this case. In any event, the information that's available to the public has already been turned over to opposing counsel. So now we're only talking about information that is not available to the public. We're talking about text messages. Obviously, the public doesn't have access to every text message you've ever sent or received. Including from medical professionals. And counsel's right. I could have decided not to look at what was there and just slid it into a disk to turn over, but I had to make sure that there wasn't privileged information there, that there wasn't confidential information there. And there was, and that's the reason that I had to go through it all. We are talking about all these text messages potentially, as far as doctor's appointments. More importantly, some of the issues is the medical conditions of other children. The obvious example is the sibling that lives in the house. There is a ton of it in there. We already had the agreement to the text messages between mother and child or messages in general. We had these agreements and then opposing counsel says no. So if she's fine with that, then I just ask that we put it into writing. It's on the record. So there's no confusion moving forward. Thank you, Your Honor.
And I just want to be clear, we didn't reach any agreements. If we had reached them, this wouldn't have been necessary and we wouldn't have a motion hearing. I wouldn't have filed a compel. She wouldn't have filed for a protective order. So sort of the fact that we've had two motions about this certainly belies that there was an agreement.
All right, here's where I am at. I think that I am falling kind of in the middle here. Request for production number 1. I think I am going to limit that to January 1st, 2021. And I do think that should be provided. Request for production number 3. And I guess just for my knowledge, so anytime they Google something, this is what that you're asking for?
It's only
yes.
It'd be if you were logged in. So I don't think it tracks it otherwise. So if you have like a Google account, if you were logged in when you did that, yes. but other people have Google Calendars and a whole bunch of other things under essentially their Gmail account. And so that's the type of things that it would get at. That's frankly, I don't really care what they Google.
No, it's location and everything that they Google.
Okay, well, I'm going to limit that. I'm going to allow that and limit it to January 1st, 2021 moving forward. The number 5. Sounds like that's already in process. Is that correct? There's just concerns about,
Sorry, let me take a look.
I'm sorry, that's the messages between Jaden and mother.
Your Honor, we've already provided that. They want text messages between Jaden and everyone he's talked to since 2021.
Okay, so this is specifically just Jaden in general. Sorry, I misread that.
And that includes also messaging on his social media, which the court already denied them access to.
And to clarify, my client asked in a parenting plan to have access to his passcodes and to be able to monitor it. That's what the court denied, not that we couldn't get it in discovery.
Okay, so number 5, I'm gonna that should be provided, and number 6. That's already limited from January 1, 2021. That should be provided. However, that information shall not leave the office of Baldwin Legal Services. I do have some concerns based on Ms. Jeffers' filings that Mr. has and may use information that is found out, especially towards the child on some of these. So I think that he should have limited access to specifically view those. I think obviously Ms. Baldwin can relay to him the information in some of these texts, but for him to just have direct purview of all text messages that involve the child, when frankly, there's been messages provided that he's used that specifically against a child, do cause concern for the court. So I think I guess I don't want Mr. Rance to just be able to sit down in a room in his own in the law office and just review all those text messages and be able to make notes about what was said. I think that information should be gone through with his attorneys present to ensure there's some limitations there. I will say that I do understand Ms. Jeffers and her client's concern with some of that information being negatively utilized. And I don't really appreciate, just for the record, the communication between dad and child that was attached to this concern. So I do just want that noted. So, and frankly, if further down the line, we find any evidence that shows dad utilized specific messages that were discovered as part of this request to negatively speak with or influence the child, then that's probably not going to be looked at too kindly by the court.
And Your Honor, I'm sorry.
No, go ahead.
I just want to clarify. So, okay, they get the messages for everybody the child talked to. With regard to mother's messages, you indicated that they need to redact anything that does not involve the child. Is that correct?
I understood the court just said that they need to provide it.
That's correct.
Okay, so you're saying her medical, any privilege stuff or information about other children or children's medical conditions need to be turned over and not redacted?
You can certainly redact anything that's truly privileged. That means attorney-client communications, not discussions about attorney-client communications. But if she texts Mrs. Jeffers or her staff, that could be redacted and certainly provided with a redaction log or privilege log.
It doesn't allow for any exclusion of attorney-client privileged communications. If there's, I guess if there's a text message specifically about some HIPAA type items that relate to somebody that's not at issue in this case.
There are.
Which would be an interesting thing to text message about, frankly, but if there is that concern, I don't know that as long as there's some kind of certification of what's being removed, I don't have any problem with specific medical information about other children in mom's home being redacted. Or I guess, you know, other family members, like if it's her mother's private medical information, or, you know, it doesn't need to be just other children, but if it's not related to her or the child in question here, I think it, as long as it's noted what and why. Okay.
So a couple, just clarifying. So my client can view the documents and materials in my office, needs to do that essentially with supervision. And then just to clarify, the exceptions would be obviously if I utilize those materials and file them, that would be an exception. So if something is raised, something, you know, I find something that's, you know, wild or inappropriate and it results in a motion, my client would be provided with a copy along with everyone else.
Yes, that's fine.
And then Ms. Jeffers, it was her motion so she can draft on for the 7th, if that works with Mrs. Jeffers, because we have another hearing on the 7th.
That's correct, Your Honor. That'll work.
All right, over to the 7th at 1 o'clock.
All right, very
Thank you,
good.
Your Honor. Thank
Thank
you.
you.
First, we're on for presentation. Ms. Jeffers submitted an order on the motion for protective order. I'm fine with that. You can write approved via Zoom for me for that.
All right, I do have that protective order. I did review that, and I will sign that. All right.
And then to the balance, I guess I'll leave it to Ms. Jeffers. We have been working to resolve the case, and so it's just up to her if she wants to address things today or see if we reach an agreement.
We haven't reached an agreement at this point, so I would like to proceed. It looks like the second issue on the docket number 3 is the final GAL report. I don't really have much to add on that. I mean, the child's struggling. The GAL indicates its anger. We've talked about him being shut down. That's where we are.
I don't think there's really anything for the court to do with that today. We're this case has been before the court a number of times. I think we are where we need to be right now with the current orders that are in place.
Okay. Anything else on this matter?
No.
All right, I do have, it looks like an old order or a brand new order. Order compelling answers to respondents' discovery requests for updated financial information. Was that on for today?
It is. That's going to be number 5, I believe, on the docket, Your Honor. Excuse me. Yeah, number 5. Is that right? Yes.
All right. And any response, Ms. Baldwin?
So my client did file a response. We provided the records both to Ms. Jeffers as well as to the court. My client's response was essentially he thought he had done it, not super tech savvy. When we then followed up, he was like, I thought that had happened, provided those records to me. We immediately provided them to counsel. Records do not indicate my client is making all kinds of money. They indicate that my client is pretty much indigent. And so that's the reality. So sort of the hidden buckets of money were not found. That's not the reason. In this case, we recognize that opposing counsel had to file the motion. I appreciate that. The same being said, the reality is that it was an unintentional error on my client's part. So we understand the court may issue some fees. I would just ask the court take into consideration my client's financial circumstances and the fact that we did provide the records.
Ms. Jeffers?
Yeah, Your Honor, mother is requesting that you sign the order to compel. We did have the 26I. They did not meet their date. Eventually, some information was provided, but it doesn't appear to be complete. If you look at the GAL report, father disclosed to the GAL that his business was doing well, and I will indicate that that is on page 3 of 12 in the GAL report. He also disclosed that he had just bought a new condo. which isn't consistent with the information that was turned over showing that he has absolutely no income. Father has been the subject of the order to compel in the past, still owes attorney fees on that. Basically, this is the exact same scenario that we were here with Mother on, except for in this case, we didn't get any response for at least 6 months. This was a lot significantly less material than what was requested by from Mother. At this point, both parties had sent materials prior to the hearing. We would request the same treatment, that the discovery be provided, that there's $500 award in attorney fees, $500 sanctions to be paid in 30 days.
Well, and I should have an opportunity to reply to that.
Yes.
Thank you. So the only issue on the compel was these bank records. That's what she asked for, and that's what we discussed at the 26 side. So we provided those. There weren't significant, or there really aren't any bank records that are associated with a business. He's trying to start a business, but just isn't there yet. And so again, the only records that they didn't receive with the prior discovery. So we'd answer discovery. This is a, hey, I want these bank records or wage stubs. There aren't any wage stubs. We say, hey, we'll get you bank records. And that's what we provided. So this isn't this idea that we've withheld everything. The only thing we're here today are these bank records. So a very select item that wasn't provided. So this isn't some idea that we've withheld buckets of data. If there are other items they specifically want, they have to ask for those. They have to plead for them. It can't just be, I didn't get what I hoped I might find. And so then I'm going to say you withheld other things that were never discussed. You have to ask for what you want and you get what you asked for. We don't have to guess at what they're asking for. So again, in this case, the only thing that was at issue were these bank records, and they were provided. I agree that they were provided after they filed the motion to compel, but when we're talking about one record out of many that we were providing an update for, that's not quite the same as withholding significant amounts.
Thank you. So I will impose $500 attorney's fees. I'm not going to impose any other sanctions. So total of $500 that will start accruing interest after 30 days. If it is not paid, I will sign off on that order compelling with that judgment.
Okay, very good. Before I enter that order,
I'm sorry, what was that?
I just verifying that you entered that order.
That ended up being the final hearing in this case. Attorney Baldwin did mention that they were close to a resolution, and it appears that they reached one. It seems unlikely that there'll be any more hearings in this case because according to the entries in Odyssey, we can see that there was an order granting a relocation entered, and also both of the attorneys withdrew less than a month after the relocation order was entered. There was also a final parenting plan rather than a temporary one ordered that same day as the relocation order. This is just more evidence pointing to the case being finalized. I hope that their son is able to build happy and healthy relationships with both of his parents without any interference from the other. They don't have long before he's grown up and gone, and they'll never get another chance to do it over. Thank you for watching.